As for example, you can, my number 1 to 5. Number 3 to 3.
Yes,
Well,
Sir.
Well,
There are two bunches in which probably you are leading.
there's a series of where the anti-tax matter, anti-tax act is.
Anti-tax, yes. The one of the matters came up before us in Itanagar. And
My
you
lord.
told Patel Engineering probably. Yes.
My lord.
Yes.
Now, this matter will take some time, and your lordship in the midst of the criminal matter.
Oh, you don't bother. We'll start the criminal matter at 2. You want to argue or you can argue.
It will better.
Has the controversy not been settled by Supreme
No,
Court?
because there are 4 points were settled by the Apex Court, and 2 points were left for the High Court to be decided, my lord.
Okay.
So I will, my lord, it will better, my lord, if your lordship can after the criminal matter, so that, my lord, with the criminal matter,
No, don't worry. Our minds will be civilized even when when we hear your cases.
Next week, any date, if your lordship fixes, then
Very well, we can do that. We, as prayed by Dr. Ashok Saraf, senior counsel representing the petitioners in some of these bunch matters, will re-notify for hearing on 23rd May.
my lord,
Okay.
because these matters were heard and judgment were reserved, may also, my lord. And thereafter, Justice Bopana was also elevated to the Apex Court. So, my lord, this matter is of such a matter, my lord, whoever when he takes the hearing,
So
my
then
lord,
please argue.
my lord, we will try to, that's why 14th, my lord, 23rd we will hear it. So whoever, my lord,
If what you said is a precedent to you, you are most welcome. Please argue.
my lord, the same thing I can assure you, my lord, when we start the hearing,
All right.
the same thing will come, my lord. I am obliged, my lord. I am highly obliged.
Yes, please.
May it
All
please
right.
your lordship and leadership.
So these are items numbers 13 to
Your
44.
lordship, item number 11, your lordship.
Hmm?
With the consent of the other side, your lordship, I pay
Which
the
item, madam?
item number 11, your lordship.
11. 11 Malik TGL and counsel for the, you are for the appellant?
Yes, yes, right.
Raise for time. The other side? You are for the other side in this case? No. List, re-notify for hearing after 2 weeks.
Your lordship, I beg to mention another item for listing.
What's the matter, madam?
It is a Mizoram police matter, your lordship, F. Lal Mingyana, WPC 2986 of 2017.
17. Why in a mentioning you can't get a 2017 matter listed? To file a proper application for early listing. We'll consider the grounds therein.
Yes, your lordship.
Old matters can't be listed on mentioning things like this. Yes.
Your lordship, my lord, I am trying for listing this matter, writ appeal, my lord. In this writ appeal, my lord, I am for the private respondent, my lord. There's an ex parte, my lord, interim order appointing against the petitioner.
What is the date fixed, sir?
My lord.
What is the date fixed by
Date-
registry?
That has not been fixed, my lord. 4 weeks time was granted.
So when was the time granted? When was the last date the matter was listed?
Before the BU vacation, my lord.
So, all right. Find out what is the date. Then we can list it on the scheduled date. You give the number, we'll find out.
My lord.
Okay.
There are many from item number 45 to 48.
Miss, please, lordship. Lordship,
Yes.
let's mention item number 48, my lord, of daily list, my lord. In this case, my lord, the youngest counsel wife is in the hospital, my lord. He is busy in the hospital right now, my lord. I'm praying that matter maybe fixed after 2 weeks, my lord.
Our
Yesterday I had
request
submitted
is
the adjournment slip also, my lord.
May I please, your lordship. Lordship, I am paying for respondent number 7 in this matter, my lord. My lord, an interim order is operating, my lord. I will pay for it, my lord.
It's a personal difficulty, Mr. Counsel. A request is made on behalf of the appellant's counsel to adjourn the case on personal ground, for personal reasons. Re-notify for hearing on 25th June, 25th May. All right.
Obliged, your lord. May I please, your lordship. Lordship, I beg to mention item number 45 and 46.
Yes,
Senior counsel Mr. Saiwala is under bereavement, my lord.
under bereavement.
My lord.
It is stated that senior counsel, Mr. Saiwala, is under bereavement and a request is made to adjourn the matters, re-notify after 2 weeks.
Much obliged.
Item number 48, my lord. 48, my lord.
48, yes.
It may
We
be,
already adjourned.
yes, man, already.
Then
Oh, sorry.
someone made a mention just before you. Or you only made a mention. You already dictated the order.
With regard to item number 49, my lord, I'm led by Mr. D.K. Mishra, senior advocate, is unwell, my lord.
It is
Maybe
stated
taken
that
up to
Mr.
3
D.K.
weeks,
Mishra,
ma'am.
senior advocate, is not feeling well, is unwell, and a request is made to adjourn the matter. List up 2 weeks.
Public.
Item number 1 for admission.
Yes.
May I please, your lordship?
Hmm?
Lordship may pass over this matter for time being as my senior is stuck in traffic.
Stuck in traffic. Okay,
Lord.
password.
For time being, lordship.
Yes, yes.
Item number 2.
May it please your lordship. My lord, in this case, we had filed this writ petition for non-issuance of the NOC to the petitioner who is a lady doctor at Guwahati Medical.
Mhm.
And she was appointed as a assistant professor in the Department of Radiation
Hmm.
Oncology. And she has been transferred to Dr. Bhubaneswar Barua Cancer Institute, of which the petitioner is an alumni of that institution, and that has some better career prospect for her.
Okay.
And it is within the state of Assam.
Hmm.
Now, against our writ petition, my lord, an affidavit in opposition has been filed. I believe, my lord, that is in the record. I will only refer, I already told, my lord,
Where is it? Affidavit has not come,
affidavit in opposition of the government filed by the respondent number 3, my lord.
not yet on the record.
Then your lordship may
It
take
was
it up.
filed yesterday. In addition to that affidavit, one further information we'd like to supplement. Lord.
Yes.
So one more day may be given for that supplementary information.
All right.
Tomorrow.
It is state, Learned Advocate General, Mr. Saikia submits that he has already filed the affidavit in opposition yesterday, and that he would be filing supplementary information when
2 days time, we are
Within-
trying to find out some more information.
2 days.
If that information comes, we'll file, otherwise we'll not file.
Okay. Thus, a request is made to adjourn the matter by a week. The interim protection granted to the petitioner by orderly date so and so will continue till next date of listing. Re-notify on
If it,
18th,
if put it on 16th lordship,
16th,
I have some percentage, but
then 17th lordship.
17th.
Highly obliged.
But
Lord.
deep level, we have also filed an additional affidavit that may also.
You
be
do that, you do that.
Deep level.
Whatever. Yes, 17th May.
Item number 3.
This was probably argued,
Lordship.
right?
Lordship.
Okay.
Lordship, yesterday, we have filed one additional affidavit in this matter, Lordship. So
Mhm.
that is in the record, Lordship.
Okay. You have filed,
Yes,
you have received.
Lordship, I have received.
Okay. Again, this will not be on record. What are the contents of the affidavit?
Lordship, here we have annexed one, is Lordship.
Uh-huh.
There we have tried to give the date of promotion there.
Date of,
Lordship, first thing here I have shown, Lordship, that on the date of appointment, Lordship, they were not in the header, Lordship, and so that's no any right have accrued in their favor, Lordship, on the date of amendment of the rule, Lordship. That is one.
Hmm.
And secondly, Lordship, the rule they have challenged that their now requirement.
yesterday. He's filed something. So yesterday filing. So we'll have,
Lordship, I have two
On it.
photocopies, Lordship. I have two photocopies.
you. Right. Hmm.
Page 125, Lordship.
Hmm.
Lordship will kindly see column 4, Lordship.
Hmm.
Lordship, that is 2015, Lordship. On that day, Lordship, they were working as
First-
senior grade computer operator, Lordship, and the rule was amended in the year 2012 itself, Lordship. And subsequently, Lordship, next column, Lordship,
Mm.
here they have been shown the date on which they have got promoted to the post of junior administrative assistant, Lordship.
All right.
And Lordship will see here, all of them got promoted prior to 4 years, Lordship.
Prior to 4 years.
Yes, that is under challenge, Lordship.
Okay, okay. So their case is that their deferment of their promotion beyond 8 years,
Yes,
that is-
not a fact, Lord.
ultra vires, that for that reason, the rule is ultra vires, whereas the fact means
Yes.
that they have been promoted before that.
Yes, Lordship. Then subsequently, Lordship, in the IA, your Lordship will file one notification of 2022, Lordship.
In the
In the IA filed by the petitioner, Lordship.
IA. Is it IA? It's there.
at page 88, Lordship.
88. Yes.
Lordship will find here the 12 notification has also been amended, Lordship.
Yeah.
And instead of 4, Lordship, now the requirement is
3 years. Now it is 3 years.
Yes, Lordship.
Oh. Hmm.
Lordship, is what they had done, Lordship. Initially, Lordship, we were eligible for promotion. We were appointed as grade 4. Lordship, typist. Then we were eligible for promotion within 4 years, Lordship. After completion of 4 years, to
Hmm.
the post of junior administrative assistant.
Yes.
Lordship, there was an arrangement whereby, Lordship, these typists were to be promoted within that 4 year. They had a scope of getting promoted, internal promotion, Lordship, within the post of typist.
Hmm.
That is the selection grade from
No,
ordinary.
that
grade.
is not a promotion, sir.
It is not exactly a promotion.
It's a
What-
financial upgradation. Selection
Lordship,
grade
what
is,
he is saying is promotion. That is not promotion, Lordship. That is what I wanted to say.
no, there is a change of cadre, change of post, sir, as per the chart. You
Lordship.
see the chart at page 125. Do you want to, you have gone through this chart, page 125.
Lordship, I have misplaced his affidavit, Lordship.
All right, then let the affidavit come on record.
Lordship.
Mr. Naik, submit that he has filed an additional affidavit yesterday. Counsel for the petitioner pays for time to go through the affidavit and address the court thereafter.
Lordship.
List after 2 weeks.
Lordship, if you record, Lordship, I will,
If
Lordship, I will
the,
file.
in the meantime, Kumar, the appellant petitioners, petitioners would be at liberty to file a response to the affidavit if so desired.
Much only.
Item number 4,
Yes.
Please, your lordship, this writ petition is directed against the order passed by the land tribunal by which the land tribunal person set aside the charge memo and putting an end to the departmental proceeding solely on the ground of delay, lordship. Whatever, lordship, in this case, the respondent was in charge of a project, lordship. He was the assistant garrison engineer looking after a project of a work for which the explosive depot has to be constructed, lordship. It was found that there was a cavity in the wall, third wall. It should have been 60 mm, but there was a cavity of 30 mm. Beside, there is the drainage area.
Cavity.
There's a layout, there is.
So negligence in construction.
Negligence in
All right.
construction. For which, lordship, of course, the period of when he was in charge, it was from 2005 to 2009.
Hmm.
We detected the shortcomings in 2011, lordship. And thereafter, lordship, we held 3 court of inquiry, lordship. First court of inquiry in 2011, then thereafter second court of inquiry in 2013, and the third one is 2014. And we issued the charge memo or so-called on 2017, lordship. So, lordship, and finally the charge.
How does the man defend himself in such a situation?
Lordship, lordship, can we see his reply, lordship? He said, I'm a new entrant to the, I have no experience. It was a first project.
Otherwise also, let us know, Mr. Chatterjee, how does the man defend himself? What is the physical evidence to prove the charge?
Lordship.
Or rather, what
No,
is the
lordship, no proceedings started, lordship.
understood that cavity, whether after 10 years, can he prove that it was not because of his negligence?
Lordship.
Was he given, when the
Lordship,
inspections were made, just hold on.
He himself admitted, lordship.
Sir, understood, when you made the inspections, did you give him any chance to explain at that point of time?
Yes, when the first so-called was issued, lordship.
In 2011?
2017.
When was the inspection made?
2017, lordship.
So when was the inspection made?
It came to a notice in 2011.
11.
Lord.
And the charge sheet was issued in 2017.
17, lordship.
So what is the guarantee that the court can be satisfied that this breach or this expansion of the cavity did not occur during the intervening period?
Lordship, can you see his reply? He himself admitted, lordship.
What is the material with you, sir? Let us know now. What is your observation?
Lordship.
When did you find out?
Lordship may come to the charge memo, page 79, lordship.
Read.
Statement of allegation is page 80, Lordship.
Yes, when did you make the inspection, sir? What is the date of construction in your charge memo?
Lordship. Article number 1, Lordship, the MES so-and-so while functioning as AG so-and-so Jehu Road during the period from 2006 to 2009 was responsible for execution of a job. He had allowed the contractor to execute the wall 16 into ESH with cavity instead of 60 cm thick solid walls, and thus he had shown gross negligence and poor monitoring construction. That during the Lordship, the article number 2, that during the aforesaid period and while functioning in the aforesaid office, the said MES BK Gupta had not done adequate supervision and physical monitoring of works which led to the poor quality and incorrect construction
So
of.
for
road
in
and-
support of this allegation, what is the material with you? When was the inspection made?
Lordship,
This is based on a physical inspection.
Lordship.
In these circumstances, delay becomes very relevant.
Lordship, list of document, page 82, Lordship.
Yes,
Number 1, proceeding of staff court of inquiry convened by so-and-so, dated 7/7.
2011.
Proceeding of TBO convened on.
Read, where is that document?
This court of inquiry has not been annexed to this petition, Lordship.
What were the observations, whether he was present there or not?
Lordship, I have recently received 2 papers. Let me bring those 2 into record, Lordship.
All right, and Council Mr. Chakravarti is directed to place on record documents referred to in the documents relied upon by the department as per the list of documents in Annexure 3 within bracket page 82 of the paper book. And we'll see.
And a third date may be given, man.
List.
2006 matter.
What is the problem for you?
And the promotion is not there, man.
Promotion is not
there.
List on 6 June. That will in the same category only, of course, for final disposal. Take that, take that.
Item number 58 of supplementary list.
Wait, please, your lordship. Lord, this is an appeal referred against the judgment dated 2nd of May 2023, passed in writ petition number 1534 of 2023. Lord, the judgment is at page 159.
Yes.
I have challenged the order of transfer dated 10/3/2023 is the said writ petition, my lord.
Yes.
If your lordship kindly comes to the transfer order first, my lord. Page 102 of the memo of appeal, my lord.
Yes.
Lord, I'll request your lordship to take note of few things in the transfer order. First, the date 10th of March 2023. Lord, I'm reading it. Keeping in view the organizational requirements following transfers, partial modifications in earlier orders, retentions are hereby ordered to take immediate effect.
Yes.
My lord, my name reflects it, serial number 3.
Okay.
I will also request your lordship to take note of serial number 2, the incumbent at serial number 2, my lord. I'll refer to him later on. I have been transferred from Subansiri Lower Hydroelectric Project to Bariasul Power Station, my lord. Lordship will also take note of that this transfer order has been issued by the Deputy General Manager HR.
Yes.
My lord, I'll draw your lordship's attention to page number 93, the transfer policy.
Policy.
The appellant,
Policies are general in transfer matters. Policies are general guidelines. They are not enforceable. There are n number of judgments on that.
Yes, my lord, I can understand the scope is very limited, my lord. Scope is very
There is
limited.
hardly any scope unless you are able to show malafide.
My lord, as such, malafide, I have not made any personal.
If
allegation,
you have
my lord.
not made so, then you yourself know
My lord,
the writing is on the wall.
my lord, but.
Why do you want further affirmation of the single bench order?
My lord,
All
I
right,
will-
carry
I will
on.
only, I will only like to draw your. lordship
Policy
attention.
is just a general guideline, sir. If you are alleging that transfer is contrary to policy, you are under a misconception that the court will interfere.
And moreover, it has not been passed by the authority competent to do so.
On that, you may argue.
Yes, my lord.
How do you say that?
Yes, my lord.
And where is that argument in the single bench? Let's see then. Where is that
My lord,
argument
I had-
addressed?
I had filed my affidavit, my writ petition was also that.
You must have made an argument.
My lord, it was in my pleadings, my lord. It was in my
Gentlemen.
pleading, very much in my pleadings, my lord. If your lordship
So
kindly allows me.
we are having the advantage of hearing a wiser counsel. Is that so?
No, my lord.
Whether that any argument was advanced, read
No.
from the order,
My lord, to be honest, no, my lord.
then chapter closed. There is an argument that too, without the approval of CMD, that is what the argument is.
Yes, my
Para
lord.
number 2.
Yes, my lord. It
Yes,
was without the approval of the CMD.
yes. So that argument is there. Let us see how it has been dealt with. Read. That argument is there at para number 2 only.
Yes. my lord.
Yes.
Petitioner is, your lordship is referring to the judgment, my lord.
Yes.
The petitioner here is working as manager civil and posted at the lower Subansiri hydroelectric project in the district of Dhemaji, excelling the transfer order at 10/3/2023 by means of which the petitioner was transferred from the Subansiri lower hydroelectric project to and posted at Biracial PS. The instant writ petition has been filed inter alia contending that this is a case of frequent transfer and the transfer order has been issued with the malafide intent of causing harassment to the petitioner. According to the petitioner's counsel, his client has been posted at Lower Subansiri hydroelectric project only 13 months back, and therefore before completion of the normal tenure of posting, the petitioner has been sought to be shifted again, that too without the approval of the chairman cum managing director. of
Right.
that. My lord, if your lord, I'll draw your lordship attention
Read para 8.
of the judgment, my lord.
Yes. So man just doesn't want to be shifted.
My lord, as per my instruction, I have no problem if they adhere to the transfer policy, my lord.
All right, send him to Tawang, Mr. Counsel. Better is he has had only one hard posting during his entire tenure.
My lord, that was.
Send him to a better place,
My lord,
Tawang or somewhere like that.
my
He will
lord,
be happier then.
my lord, in fact, I have served.
You just read para 6, para 8.
Right.
All transfers within same offices. He is a good manager, it seems.
Well, I can show it from record
Read,
that
read para 8, please.
by means of his pleadings in the writ petition, more particularly the table at para 5 of the writ petition, an attempt has been made by the writ petition to project that he has been subjected to frequent transfer. However, on a closer scrutiny of the table given at para 5 of the petition, I find that the petitioner has been effectively transferred only on 6 occasions in his 19 years of service career, as the other transfers were all from one office to another within the same location, and therefore would not come within the meaning of frequent transfer. 6 transfers in a span of 19 years by any stretch of reasonable reckoning in the opinion of the court cannot amount to frequent transfer. And if your lordship allows me, may I refer to the table at para 5, my lord?
And come to para 9 also. We'll rather affirm and we'll ask the employer to consider adhering to the policy in strictly so that you can now be assigned a harder posting. You have enjoyed the fruits of a soft posting for 10 years. That is more than enough. We'll make those observations if you want.
My lord, if it is the case of if it is the case of the respondents,
Yes.
that since I am needed to be posted out of Subansiri Lower Hydroelectric Project, and therefore they will transfer.
Yes,
Me to
your
the-
services are required more at the place where they've sent you. You are not enjoying working, resign. What is the
My
problem?
lord, it's not that I'm not
Then
enjoying
all
working, my
right.
lord. My lord,
Transfer incident of service.
my lord, the irony is that, my lord, for transfers, for the purpose of transfer, I am found most suitable, and for the purpose of promotion, I am found the most unsuited man, my lord.
Yes, right. Because he's somehow or the other managing to hold on to the soft postings for
No,
decades.
It's not that, my lord. I had served 7 years, 10 months in hard posting. My
Yes.
starting was at hard posting, my lord.
Yes, yes.
Yes, since 2004 to 2011, I was in a
Yes.
hard station, my lord.
So since 2011 to 23, he's in a soft station. The policy says not more than 10 years.
Yes, my lord. I was not in the same cluster also, my lord. If your lordship allows me, I can refer to that table in paragraph 5. For a moment, my
Do
lord.
it at your own peril then. Draw the observations of the court, which could lead to another catastrophe so far as the petitioner is concerned. Transfer matters unless there is
My lord,
any allegation of malafide.
My lord, I can understand very
Hmm.
very
Yes, sir, you
limited
can
scope, my lord.
understand that you have tried your luck, sir. Transfer this. You argue, all right, continue. We'll take note of your
Yes,
arguments. We'll
My
not
lord,
stop
if
you
you're-
from arguing.
Yes, yes. my lord.
Yes. So what are your arguments? You let us know. We'll note down your arguments so that we can deal with them properly.
My lord, the table, I have mentioned this, your lordship will find it at page 6 of the memo, my lord.
Hmm. Yes.
Your lordship will note Parvati 2 project head race tunnel construction, number 1.
Hmm.
It is a hard posting, my lord.
Yes.
I'll show you if your lordship takes up the transfer policy. Page 9. Your lordship may kindly come to page 96, my lord,
Yes.
under note
Hmm.
1, 2, 3. The fourth line, the third line, my lord. Silgar and Harsaini in Parvati 2, these are hard posting, my lord. And this race tunnel construction falls under that.
Right.
My lord, thereafter, from 2011, this Kolkata regional office is nowhere amongst the cluster, my lord.
Hmm.
Earlier,
Hard posting. Is that a hard posting?
it's not a hard posting.
You are,
but it's
if you
not
were aggrieved
definitely-
by that transfer, you should have approached the court. All right.
My lord, but it's definitely not not the same cluster, my lord.
Right.
It doesn't fall within any of the clusters.
Right.
Thereafter, my lord,
Tista.
Tista to Siliguri.
Tista,
this falls
Tista,
under the same
Siliguri.
region, same
Tista,
cluster.
Siliguri, Tista, Siliguri,
Yes, my lord.
then Subansiri.
Yes, my lord, till 2021. Tista falls under the same region. Subansiri is a different region, but the same cluster, my lord.
So
So,
from
my lord, if there are
2014 to 2023, it is virtually the same cluster.
yes, my lord. From
Hovering around
2014
the
to-
same
but
area.
It doesn't complete 10 years, my lord.
Yes. All
But
right.
It doesn't complete.
So all,
10
that
years.
is why you have not been sent to hard posting. Let the 10 years be completed and they'll consider your case
Yes, my lord.
for
I'm
hard
ready-
posting.
My lord, I'm ready for that, my lord.
Yes,
I'm
so
ready
all
for
right,
that.
you are inviting that observation by this court. Ask your
And-
client
And
whether he wants such an observation now.
my lord, if your lordship gives me some time, I can take instruction. Your lordship will take
15
the matter
minutes.
after some time, my lord.
15 minutes time.
Yes, my lord.
I could have answered it, my lord. Parvati 2 is not hard. It's soft.
Don't bother, sir.
And it has the approval of CMD.
Must
It
be,
has the approval.
we can presume. Otherwise, the single judge would have interfered.
Yes.
Yes. Take it, call it out, call it out. Call it out.
Matter number 1, passed over matter.
Please, Your Lordship.
Yes.
My lord, I am appearing on request of Mrs. D. Good, my lord. She lacks in another good. May kindly pass out for the time being, my lord.
This is the second pass over for timing, not, now it's not possible. So let's after 1 week.
If it is not inconvenient, may I pray for a date, Lord?
Whatever date you want, sir.
Yes, Lordship.
Whatever is convenient to you,
No, Lordship, I'm always.
whatever date you feel like you can tell the court master. please.
Lordship. Much obliged.
We'll ask them, Mr. Chaudhary,
Yes.
you are sitting in item number 5.
Five, my lord.
What is the matter about?
My lord, regarding a selection to grade 1 of, judicial.
Judicial services.
Yes. From Arunachal Pradesh, my lord. A very short point is involved, my lord.
What is it? Now it's too long in the day. 2016 selections.
But my lord, what would be? My lord?
After that, there must have been more selection processes.
No.
No, 2016 till now. This is grade 1, that is DJs.
No,
District Judge cadre.
that was the last.
District Judge cadre.
Yes, district is grade 1.
Okay.
Grade 1.
What is the argument?
The argument is, my lord, the rule says the aggregate of written and interview. But in the advertisement provision was inserted, my lord, that in the interview.
Minimum marks.
60%.
Yes, that now the Supreme Court has affirmed.
Tanya Malik and all.
Yes.
No, my lord,
Shiraz.
As the law prevailed, then it did not, my lord. I'll just place the facts, my lord.
Yes, definitely.
My lord will kindly take the writ petition.
Yes,
Page 30, my lord, I'll draw your lordship's attention to the advertisement. Page 30, clause 10.
yes.
All candidates who obtain 60% or more marks or corresponding grade in the main written
In
examination.
the Viva, see out of so and so will have to
Yes.
secure
The
minimum.
last 3 line, my lord.
Yes,
In the Viva VOC, out of 50%,
Yeah, we have read that.
50 marks, the candidate will have to secure minimum 60%. However, final selection shall be made subject to overall suitability to be decided by the High Court.
yes. So that
Now we are
50% is a, overall suitability is a criterion.
Yes, that is.
So that minimum marks can fix in that.
Yeah.
That we have done in Rajasthan and that has been sustained.
No, my lord, here, here the rule is otherwise, my lord.
Rule in Rajasthan was similar such.
But in that case, what meaning will give to the all previous judgments of the Supreme Court?
The latest judgment, what you will do?
All, then Shetty Commission's
We'll
recommendation.
tell you, Mr. Chaudhary, practically,
Yes,
we were holding, the earlier position in Rajasthan had been altered. Earlier on, it was minimum marks was prevailing. One honorable Chief Justice thought, no, this is not proper. So the position in the rules was changed. And then we had a selection process wherein against 45, 5 people were selected, direct recruitment. And when that was my first opportunity to sit in the interviews. And the comments coming from the then Honorable Chief Justice were that your decision to reverse that minimum marks position will cause us to select at least 4 incompetent persons as district judges in the judiciary. That was the comment. So this thing you will realize if you are a part of the interview board only.
no, I appreciate, my lord. In an appropriate case, certainly that would be.
And all right, one more question.
Yes,
So this introduction is as per you contrary to the rules.
yes.
Whether this condition was challenged before participating or
No,
after
no.
participating. Okay,
No, and that also Supreme Court has said is not
Yes.
required.
yes,
If a lordship should kindly come to page 44, my lord,
yes,
of the writ petition.
44.
Yes. This is the, my lord, total sheet, my lord. Serial number 1, Hage Lampu is the petitioner, my lord.
Mm,
In written, he got, my lord, 170.5,
mm,
and in interview, he got, my lord, 21.33.
mm.
Aggregate is 191.83. Highest mark, my lord.
Highest marks.
Yes.
Mm,
Then serial number 2, his respondent number 5. In written, he got 150, my lord.
mm,
And in the interview component, it was 38.67. So it was 188.
mm.
Then serial number 3, Gote Mega,
He got 153.5.
What was the marks in, minimum marks in Viva was it?
Viva was a marks are.
Viva was it total marks were?
J, K and L. Column J, K and.
K and L.
Yes, there were three members, my lord.
Okay.
Interview board. So
And
it
what was out of the marks were out of 50?
50.
Okay.
Yes. And then my lord, Gote Mega got 153.5 in written
Mm.
and 35 in.
How many posts were advertised?
Two, my lord.
Two.
And my lord, serial number 4, Gimi Tarak, he was put in the wait list. He's respondent number 7.
Mm.
He got 151.5
Oh.
in written, and my lord, Viva was he got 183.3. So going by the rules, my lord, having secured 191.83, I am qualified. I should have been appointed.
Okay.
Now, my lord, let me place my case.
Mhm.
My lord will kindly have a copy of the.
And why the name of Gimi Tarak struck off? What was the reason?
Gimme.
All right, only one would be affected as
Yes, yes.
if at all your writ was to be
Yes,
accepted.
yes.
Yes, all right.
My lord, lots will have a copy of the rule.
The rules are there. We
Yes.
are having the rules
Yes.
in the record. Yes.
My lord will kindly come to the rules.
Yes.
There is no dispute about my lord, 25%. I can be by way of my lord, recruitment from the bar. Please
Hmm.
come to page 8, my lord, of the rules.
Page 8.
8. Now, schedule B, competitive examination, my lord. I'll have your lordship's attention to C, general instruction.
Your
Towards the
rule,
bottom, my lord, of page 8.
page 8.
Towards the
Yes.
bottom. C, general instruction.
Mm.
All candidates who obtain 60% or more mark or corresponding grade in the written examination shall be eligible for Viva Voce examination, provided that Arunachal Pradesh scheduled tribe candidates who obtain 50% or more marks or corresponding grade in the written examination shall be eligible for the Viva Voce exam.
Mm.
2. Selection of candidates shall be made on the basis of cumulative grade obtained in the written and Viva Voce. I am on this one.
Mm. Three also. That minimum marks comes from the power conferred by clause 3, suitability.
Yes.
So the High Court has decided that for deciding a suitability, this is the benchmark which has to be fixed. That is at par with the written examination.
My lord, I'm on a slightly different plan, my lord.
Yes.
I'll rely on some of the judgments of the Supreme Court,
Yes.
from which lordship will have to take a call on the permissibility of the course of action adopted by the High Court.
Right.
And that yes,
Now we have the
bunch of.
bunch of judgments. We have it. You are citing.
Okay.
What
My
are you
lord,
citing?
First, I'll rely on, can I give this, my lord? I've already made two. Oh, acha, it's already. Please come. Huh? I think these are the judgments given by the other side. You have given some judgment?
No, I have.
There is one division bench judgment of the Guwahati High Court also.
Yes, my lord.
What is that on? High Court Bar Association versus Guwahati High Court,
Yes,
Kwete, Chope. What is the issue involved in that?
my lord, same issue, my lord.
Same issue.
Yes.
And what is the view taken?
The view taken in, my lord, tune with K. Siraj, my lord, that there is, the High Court has all the power to prescribe the qualifying marks, minimum marks in the interview as per the rules, my lord. Because therein also, my lord, this clause-
23.
division bench.
Question is, my lord, the Supreme Court judgment came after the selection, my lord. So their judgment will operate prospectively.
Guwahati High Court division bench.
No, it's 23 judgment.
Which
Judgment of 2020, 23, my lord.
you are talking about the
Division bench.
Okay. No, lordship will consider that also. Let me place 2-3 paragraphs, my lord.
all right, all right.
First, my lord will kindly come to Rakhi Ray judgment in the compilation at page 8.
This one.
This is, my lord, the 2010 2 SCC 637.
Yes.
My lord will kindly have para 19 at page 8. So far as the judgment of this court in Himani Malhotra is concerned, the facts are quite distinguishable. The Delhi High Court did not frame any statutory rule providing for cut-off marks in the interview for assessing the suitability for selection. After the selection process has been initiated, such a resolution was adopted. Therefore, the basic issue for consideration before this court had been as to whether it was permissible for the High Court to change the selection criteria in the midst of the selection process.
This is distinguishable on this
No,
aspect.
no, I'll come to
There is
that.
no change in criterion after the selection.
Yes, after it. The
Yes.
court, placing reliance upon its earlier judgment, held that once selection process starts, it is not permissible for the competent
Rules
authority.
of
to-
the game cannot be changed once
Yeah,
the ball
yes.
set
Correct.
rolling.
Once,
Yes.
yes. No, my lord will kindly come to the placitum A, my lord, at page 9.
Yes.
Undoubtedly, the court had taken note of Justice Sethi Commission report in this regard and held that such a criteria could not have been provided.
Hmm.
In absence of any statutory rule governing a particular issue, direction issued by this honorable court would prevail.
Hmm.
End of the day, what honorable Supreme Court said was, my lord, if there is no statutory rule, in that case, the Delhi High Court was bound to follow the recommendation of the Sethi Commission as approved in the All India Judges Association scheme.
Right.
And Sethi Commission says, my lord, there should not be any minimum cutoff as far as interview component is concerned.
Okay. Very well.
Then, my lord, next para 20. Therefore, it is evident from the aforesaid judgment that in spite of acceptance of recommendation made by the Justice Sethi Commission, this court insisted that existing law statutory rule in making the appointment of judicial officers be amended accordingly. In so and so, this court repealed the contention which is being advanced by the learned counsel for the petitioners therein. And the court in a crystal clear words held that appointment have to be made giving strict adherence to the existing statutory provision and not as per the recommendation of the Justice Sethi Commission. Of course, in the absence of statutory rule to deal with a particular issue, High Court are bound to give effect to the direction of this court. My lord, in my humble understanding, subject to what your lordship may say, my lord, what is the principle which is judiciable is, my lord, if there is a statutory rule, then follow the prescription in the rule. If there is no rule, then you are bound to follow Sethi Commission recommendation. Then my lord will kindly come to next judgment, that is All India Judges Association's case at page 33.
Yes.
All India Judges Association, 2002, 4 SCC, 247, para 27.
Yes.
My lord will kindly come to page 33, my lord.
Yes.
Please come to my lord, placitum F at para 27. The subordinate judiciary is the foundation of the edifice of the judicial system. It is therefore imperative, like any other foundation, that it should become as strong as possible. The weight of the judicial system essentially rests on the subordinate judiciary. While we have accepted the recommendation of the Sethi Commission, which will result in increase in the pay scale of the subordinate judiciary, it is at the same time necessary that judicial officers, hardworking as they are, become more efficient. It is imperative that they keep abreast of the knowledge of law and latest pronouncement, and it is for this reason that Sethi Commission has recommended the establishment of the Judicial Academy, which is very necessary. At the same time, we are of the opinion that there has to be certain minimum standard, objectively adjust for officers who are to enter the higher judicial services as additional district judge and district judges. While we agree with the Sethi Commission that recruitment to the higher judicial service, that is district judge cadre from amongst the advocates, should be 25%, and the process of recruitment is to be made by competitive examination, both written and viva voce, we are of the opinion that there should be an objective method of testing the suitability of the subordinate judicial officers for promotion, etc. So, my lord, I have read this passage for the purpose of showing, my lord, that in this case, my lord, the Sethi Commission's recommendation was accepted, my lord. Then, my lord will kindly come to the next decision, that is Himani Malhotra at page number. Himani Malhotra is 2008, 7 SCC 11, page 11, para 17 and 18. And in the compilation at page 47, my lord. Para 70, my lord will kindly come to placitum C. There is no manner of doubt that prescription of 750 marks for viva voce test is on the higher side. This court further notices that the Honorable Justice Sethi Commission has recommended in his report that the viva voce test should be in a thorough and scientific manner, and it should take anything between 25 to 30 minutes for each candidate. What is recommended by the commission is that viva voce test shall carry 50 marks and there shall be no cut-off marks in the viva voce test.
Okay.
This was the recommendation of the Sethi Commission.
Yes.
This court notices that in All India Judges Association, subject to various modifications indicated in the said decision, the other recommendation of the Sethi Commission were accepted by this court. It means that prescription of cut-off mark at viva voce test by respondent was not in accordance with the decision of this court. It is an admitted position that both the petitioners had cleared the written examination, and therefore, after adding the marks obtained by them in the written examination to the marks obtained in the viva voce test, result of the petitioners should have been declared. As noticed earlier, 16 vacant posts were notified to be filled up, and only 5 candidates had cleared the written test. Therefore, if the marks obtained by the petitioner at viva voce test had been added to the marks obtained by them in the written test, the names of the petitioners would have found place in the merit list prepared by the respondent. Under these circumstances, this court is of the opinion that petition filed by the petitioner will have to be accepted in part. So, my lord, first, the Sethi Commission recommendation was accepted. And secondly, it says, my lord, in referring to All India Judges Association case, that the minimum fixation of any cutoff mark for viva voce.
The line is, it means that prescription of cutoff marks at viva voce test. So
Yes.
it was a subsequent development. It was not indicated. This judgment doesn't say that this condition was prescribed in the advertisement
No,
itself.
my lord. My lord, there are, I'll come to that also. My
Yes.
lord, in fact, my lord, there are judgments of the Supreme Court. If the advertisement is contrary to the rule, then that itself is bad.
All right.
I'll place those judgments.
Yes.
Then, my lord, regarding participation part, let me place the judgment of Ramesh Kumar, my lord. 2010, 3 SCC 104, paragraph, my lord, 18. Regarding that participation part, my lord, at page number 71 of the compilation.
Yes.
Please come to page 71, para 15. Thus, the law on the issue can be summarized to the effect that in case the statutory rule prescribe a particular mode of selection, it has to be given strict adherence accordingly. In case no procedure is prescribed by the rule and there is no other impediment in law, competent authority, while laying down norms for selection, may prescribe for tests and further specified minimum benchmark for written tests as well as for viva voce.
Yes.
In the instant case, the rules do not provide for any particular procedure criteria for holding the test. Rather, it enables the High Court to prescribe the criteria. This court in All India Judges Association's case accepted Justice Sethi Commission's report in this regard, which has prescribed for not having minimum cutoff mark for interview. The court further explained that to give effect to the said judgment, the existing statutory rule may be amended. However, till amendment is carried out, the vacancies shall be filled up as per the existing statutory rule. A similar view has been reiterated by this court while dealing with the appointment in so and so, so and so, so and so. That where statutory rules do not deal with a particular subject / issue, so far as appointment of judicial officer is concerned, direction issued by the court would have binding effect. But in our case, my lord, not only there is a rule and plus Sethi Commission recommendation. Now, para 18 is regarding the participation part.
Yeah.
These cases are squarely covered by the judgment of this court in Himani Malhotra, wherein it has been held that it was not permissible for the High Court to change the criteria of selection in the midst of the select process. Of course, that is not the facts here. This court in All India Judges Association had accepted the Justice Sethi Commission's report in this regard. That is, there should be no recruitment requirement of securing minimum marks in the interview. Thus, these ought to have been given effect to. The court had issued direction to offer the appointment to candidates who had secured the requisite mark in the aggregate in the written examination as well as in the interview, ignoring the requirement of securing minimum marks in the interview. In pursuance of those directions, Delhi High Court offered the appointment to such candidate Selection to the post involved herein has not been completed in any subsequent years to the selection process under challenge. Therefore, in the instant case, in absence of any statutory requirement of seeking minimum marks in the interview, High Court ought to have followed the same principle. In such a fact situation, question of acquiescence would not arise. This is the answer. In such a fixed fact situation, question of acquiescence would not arise. My participation will not take away my right. Then my lord will.
Has there been, Mr. Nath, Ms. Da, has there been any recruitment in the intervening period since 2015 onwards?
To my instruction, no, my lord. That was the last.
Then my lord will kindly have page 97 that RAS regarding my lord participation in all case will not operate as my lord estoppel. My lord will kindly come to page 97 and the judgment is 1997 9 SEC 527 paragraph 16.
Yes.
My lord will kindly come to Placidum D. It is true as contended by Sri Madhava Reddy that this court in Madan Lal and other decisions referred therein had held that a candidate having taken a chance to appear in an interview and having remained unsuccessful cannot turn around and challenge either the constitution of the selection board or method of selection as being illegal. He is stopped to question the correctness of the selection. But in this case, government have committed a glaring illegalities in the procedure to get the select candidates for examination under 55 rules. So also the method of selection and exercise of power in taking out from the purview of the board and also conduct of the selection in accordance with the rule. Therefore, the principle of estoppel by conduct or acquiescence has no application to the facts of this case. Thus, we consider that procedure offered under 55 rule adopted by the government or committee, as well as the action taken by the government are not correct in law. So in all situations, it will not operate as an estoppel, my lord. Then, my lord, the last decision is at page 99, my lord. Raminder Singh versus State of Punjab is an authority for the proposition. If the advertisement is contrary to the rules, then there is no question of challenging the advertisement, my lord. 2016, 16 SEC 95. My lord will kindly come to page 104, para 24 and 25.
Yes.
At 104. The learned counsel for the respondent, however, contended that the appellant did not possess the requisite qualification that was necessary for the promotional post as prescribed in the advertisement, and hence cancellation of the appellant's promotion was appropriate. We do not find any force in this contention. As held supra, the appellant had fulfilled the necessary criteria prescribed in Rule 10. It was, in our view, sufficient compliance for in-service candidate. Anything prescribed in the advertisement which was dehorsed the rule was bad in law.
Yes.
So, my lord, therefore, to sum up my argument, my lord, it's a very simple case where there is a set of rule which govern the selection to grade 1 of this honorable court service of this honorable court.
Yes.
My lord, where amongst others, there will be written test and interview, and aggregate of 2 will be taken note of for finding out whether anyone is eligible for selection. Now that prescription has been, done away with. On the contrary, in the advertisement, my lord, a clause was inserted that minimum 60% one has to acquire.
Read clause 6 of the evaluating performance criterion.
My lord,
Page 9 of the rules, clause 6. Below the evaluating performance in competitive examination for judicial selection.
one second. Page 9, I'm sorry.
Page 9 of rules. Just after the rule.
Evaluation performance in competitive.
Yes, clause 6, last 2 lines.
What happens if there are several successful candidates obtaining the same grade and the available positions are fewer in number? How do you rank them to determine who is to be given the job? Of course, this situation can develop with numerical marking also, where persons with 1 mark or half a mark difference are given advantage. This is unfair given the fact that in actual practice, this may happen because of play of subjective element on the part of the individual examiner. What is therefore recommended is a similar vigorous and objective grade value exercise for viva voce examination as well. Yes, it is there. No, Malo, whether that situation was there in this case.
That is not the only governing factor, sir.
No,
The clause 3, if you will read,
yes,
the object of the viva voce examination is to assess the suitability of the candidate.
Correct.
So for examining the suitability, if
yes.
the High Court decides to keep a benchmark, whether that can be considered to be unconstitutional, that is what the general idea is.
No,
Anyhow,
on
we'll
the,
see.
on the contrary, my submission would be, my lord, when there is a 309 rule, well, there has to be a very good reason to, I mean, depart from the prescription. in the-
Can it be called a departure?
It's a departure, my lord.
Oh, it is.
It's a departure. My lord, it's not me who have said it, the Honorable Supreme Court of India which has said.
Very well.
Honorable
We'll see.
Sethi Commission said, which was accepted by the Supreme Court.
Let us see.
No,
let
my
us
lord,
see.
even this particular clause 3, my lord,
Yes,
one second. That's
there is no
it.
prohibition in the rules that minimum marks cannot be prescribed.
Yeah.
There is no prohibition in the rules. So can you say that the condition introduced in the advertisement is contrary to the rules? At best, you can say rules are silent and you have introduced the condition.
No, rules are silent.
So
Rules are
it's,
silent.
so the introduction of the condition is not contrary to the rules.
No, my lord.
There's a slight difference in
No, my
situation.
lord, whether we will look at that negative point from the point of view or we'll look at the, my lord, positive point. Question is, no, my lord, what meaning we give to the Sethi Commission recommendation
That
which
that
has been
argument we
accepted by the Honorable
That
Supreme Court?
that we understand.
Yes.
Let us see what is the later view of the Supreme Court on that.
No, later view will operate perfectly. I'm
No,
not on
no,
that.
That's
The
that
later
can't-
view of, my lord, every judicial
Yeah,
pronouncement.
you are of course permitted to argue that. But let us see in view of the peculiar circumstances
Yes.
where the rules do not prohibit fixing of a criterion. Suitability is a very wide term, Mr. Chaudhary. And
Well,
practically we have seen that.
No, well, I think I have an answer to what is fallen from your lordship. When your lordship says rule is silent, therefore it doesn't mean, my lord, in that case, my lord, this honorable court will be legislating the rules.
And
The rule-making authority never thought it fit
very well,
that there should be a fixation of minimum percentage of marks in the interview.
right.
Now, if your lordship takes over that function, then my lordship will be making the rule.
True.
Therefore, my humble, it's a very open and shut case in my humble submission. It's a very clear case, my lord. At least until this election took place, the law on the point was there cannot be minimum fixation of, I mean, marks. And there are ample number of authorities which support the view which we have taken. Therefore, in my humble submission, my lord, non-selection of the petitioner was wrong. And therefore, lordship, in my humble submission, lordship will issue appropriate direction to my lord, appoint the petitioner, and in that process, my lord, naturally, person who secured lesser marks from the bottom will have to make room for the petition.
All right.
That is my humble submission.
Yes.
May please, Your Lordship.
Mm.
My lord, first thing I'd like to clarify one thing, my lord. There is a full court decision by this honorable court.
Full
Perhaps
court,
Full court decision on the, by this,
full court resolution.
sorry, my lord.
It's a
Full
resolution.
court resolution
Yes.
by this honorable court wherein decision was taken to fix this cutoff mark,
Mhm.
60% cutoff mark in the interview
Mhm.
for selecting a candidate, my lord. And that full court decision was taken, and this entire clause in the advertisement was incorporated in
On the basis of this full court
full court
resolution.
decision. Now, at the very outset, my lord, my first objection is that the advertisement was issued in 17/10/2015. My lord, admit cards issued on 29/10/2015. Preliminary examination was held on 15/10/2015.
notification of preliminary examination was declared on 5/1/2016. Then written examination of mains was held for paper 1 and paper 2 on 22/2016 and paper 3 21/2/2016, and thereafter, the results were declared on 22/4/2016. Viva voce held on 27/4/2016.
That is, you're narrating these facts to make a statement
In
that he
between-
did not challenge the condition before
between-
participating.
Yes, my lord. In between, 1 year had elapsed. There was no challenge to the advertisement or conditions incorporated in the advertisement that this is violation of the rule. So para 3 of my affidavit in opposition, if your lordships kindly take up.
Hmm.
My lord. My specific contention,
Para 3 of your affidavit?
affidavit page 4, my lord.
Yes.
The petitioner was well aware of the prescription of qualifying marks in Viva
That
voce.
you need not even say in the affidavit, that is there, that is made out from the advertisement itself.
Exactly, my lord.
Yes.
So in this regard, my lord, all the Supreme Court judgments, my lord, took into consideration this aspect of the matter along with the, my lord, prescription of cutoff marks in Viva voce.
Hmm.
These two aspects are decided in all the cases. My lord, firstly, lordship has already seen the clause 3 of the rules.
Hmm.
It says the object of the Viva voce examination is to assess the suitability of the candidates for the cadre by judging the mental alertness, knowledge of law, clear logical exposition, balance of judgment, skill, attitude, ethics, power of assimilation, power of communication, character, intellectual depth, and the like of the candidate. So if we compare this scope given by the rules vis-a-vis the law laid down by the Honorable Apex Court and Shiraj, if your lordships, my lord, I have given a compilation.
Yes.
Yes. The relevant paragraphs will be paragraph 49, 50. Yes. Citation is 2006 6 SCC to 395. 395. Para 49.
Yes.
May I read, my lord? So far as the first submission is concerned, we have already extracted Rule 7 in paragraph supra. The Rule 7 has to be read in the background, in this background, and the High Court's power conferred under Rule 7 has to be adjudged on this basis. The said rule requires the High Court firstly to hold examinations written and oral. Secondly,
Yes.
the mandate is to prepare a select list of candidates suitable for appointment as so and so. The very use of the word suitable gives the nature and extent of the power conferred upon the High Court and the duty that it has to perform in the matter of selection of candidates. The High Court alone knows what are the requirements of the subordinate judiciary, what qualities the judicial official should possess, both on the judicial side and on the administrative side, since the performance of duties as a munsif or in the higher categories of subordinate judge, chief judicial magistrate or district judge, to which the candidates may get promoted, require administrative abilities as well. Since the High Court is the best judge of what should be the proper mode of selection, Rule 7 has left it to the High Court to follow such procedure as it deems fit. The High Court has to exercise its power in the light of the constitutional scheme so that the best available talent suitable for manning the judiciary may get selected. Then next para 50, my lord. What the High Court has done by the notification dated so and so is to evolve a procedure to choose the best available talent. It cannot be for a moment be stated that prescription of minimum pass mark for the written examination or for the oral examination is in any manner irrelevant or not having any nexus to the object sought to be achieved. The merit of a candidate and his suitability are always assessed with reference to his performance of the examination, and it is well accepted norm to adjust the merit and suitability of any candidate for any service, whether it be Public Service Commission or any other. Therefore, the powers conferred by Rule 7 fully justified the prescription of minimum eligibility condition in Rule 10 of notification dated so and so. The very concept of examination emphasized by Rule 7 is a concept justifying prescription of a minimum as benchmark for passing the same. In addition, further requirements are necessary for assessment of suitability of the candidate, and that is why the power is vested in a high-powered body like the High Court to evolve its own procedure, as it is the best judge in the matter. Now, next para, my lord, will kindly see para 51. The very scope and amplitude of Rule 7 under which selection is made is sufficient answer to the contention of the appellant. Under the scheme of Indian Constitution, the High Court is vested with entire administration of subordinate judiciary under Article 233, 234, 235 of the Constitution of India. High Court is vested with the power to see that the high tradition and standard of judiciary are maintained by the selection of proper persons to man the subordinate judiciary. Now, para 57, my lord. The
Read
quality,
para 54 before that.
lordship. In our opinion, yes, my lord. I'm sorry, my lord. In our opinion, the interview is the best mode of assessing the suitability of a candidate for a particular position. While the written examination will testify the candidate's academic knowledge, the oral test alone can bring out or disclose his overall intellectual and personal qualities like alertness, resourcefulness, dependability, capacity of discussion, ability to take decision, qualities of leadership, etc., which are essential for the judicial officer. Now, para 57.
Yes.
The qualities which a judicial officer would possess are delineated by this court in Delhi High Court Bar Association versus Union of India. A judicial officer must, apart from academic knowledge, have the capacity to communicate his thoughts. He must be tactful, he must be diplomatic, he must have a sense of humor, he must have the ability to diffuse situation, to control the examination of witnesses, and also lengthy irrelevant arguments and the like. The existence of such capacities can be brought out only in oral interview. It is imperative that only persons with a minimum of such capacities should be selected for the judiciary, as otherwise the standard would get diluted and substandard staff may be getting into the judiciary. Acceptance of the contentions of the appellant petitioner can even lead to a postulate that a candidate who scores high in the written examination but is totally inadequate for the job as evident from the oral interview and gets 0 mark may still find a place in the judiciary. It will spell disaster.
No, there is one more proposition. A candidate may choose not to appear.
Yes.
What happens then? He has secured the very high marks in the return.
Yes, my lord.
He says that forget about it, I'm not appearing.
Yes,
Then what? If the minimum marks is not there,
exactly, my lord.
then the
They
candidate can still say or refuse to stay tight-lipped, not reply any question.
Exactly.
What happens?
Yes.
If the minimum marks are not there, then candidate
will
will
be
say,
tight.
irrespective thereof, you give me 0 marks, still I'll succeed.
Yes,
I'll be selected.
yes.
Yes.
It will spell disaster to the standards to be maintained by the subordinate judiciary. It is therefore the High Court has set a benchmark for the oral interview, a benchmark which is actually low, as is required 30% for a pass. The total marks of the interview are only 50 out of the total of 450. The prescription is therefore kept to the bare minimum, and if a candidate failed to secure even this bare minimum, it cannot be postulated that he is suitable for the job of Munship Magistrate as assessed by 5 experienced judges of the High Court. Now, para 62, my lord. Thus, it is seen that apart from the amplitude of the power under Rule 7, it is clearly open to the High Court to prescribe benchmark for the written test and oral test in order to achieve the purpose of getting the best available talent. There is nothing in the rules barring such a procedure from being adopted. My lord, this is important.
Yes.
It may also be mentioned that executive instructions can always supplement the rules which may not deal with every aspect of the matter. My lord, even there is nothing in the rules. Executive instruction can supplement, my lord. Here also in this case, my lord, there is a full court resolution. Yes, my lord, to prescribe that cutoff mark, my lord.
Right.
Yes. Even assuming that Rule 7 did not prescribe any particular minimum, it was open to the High Court to supplement the rule with a view to implement them by prescribing relevant standards in the advertisement for selection.
Yes.
So, my lord, this is the view taken by the
Has this judgment been dealt with any of the subsequent judgments?
Cited by my learned senior. Yes, para 73, my lord, lordship will kindly have a look. This is with regard to after participating in the selection. The appellant petitioner,
Yes.
having participated in the interview in this background, it is not open to the appellant petitioners to turn around thereafter when they failed at the interview and contend that the provisions of a minimum mark for the interview was not proper. It was so held by this court in para 9 of Madan Lal versus state of Jammu and Kashmir. Before dealing with this contention, we must keep in view the salient fact of that the petitioners as well as the contesting successful candidates being respondents concerned therein were all found eligible in the light of the marks obtained in the written test to be eligible to be called for order.
The estoppel was considered.
Yes, this is therefore paragraph 74, it says, therefore the writ petition filed by the appellant petitioners should be dismissed on the ground of estoppel is correct in view of the above ruling of this court. The decision of the High Court holding to the contrary is per incuriam without reference to the aforesaid decision.
Yes.
Yes. Yes. And in para 72, my lord, the Supreme Court, Honorable Supreme Court took note of the decision of Kerala High Court in Remani. This is because that was the earlier decision of High Court in the state of Kerala, my lord, para 72.
Yes.
Now, the Naik judgment, your lordship will kindly take, that is 2018 14 SCC, page 129. The relevant paragraphs will be, my lord, 18, 19, and 21.
2014.
Yes, my lord.
2018.
Page 2018.
You are
14.
reading Tanya Malik.
Yes, my lord.
All right.
Page 49 of
Yes.
that compilation.
This citation to be
2018 14 SCC.
Tanya Malik is the leading judgment on this issue. Yes.
Yes, my lord.
Mm.
129. Tanya Malik. Lordship will kindly refer to para 18, 19, and 21. Page 63, Lordship will find.
Mm.
Coming to the question of prescribing the minimum pass mark in the Viva Voce examination, in our opinion, it is rightly observed by this court in case Shiraj that interview is the best method to assess the ability of the candidate and to judge the capacity, and minimum marks can also be prescribed. In a case, in case a candidate fails in interview, it cannot be said that he is suitable for the job of a municipal magistrate. Thereafter the paragraphs of K. Shiraj,
Have been
they were quoted.
reproduced.
Then I'll
Yes.
just take your lordships directly to para 19.
Mm.
In our considered view, it is desirable to have the interview and it is necessary to prescribe minimum passing mark for the same when the appointment in the higher judiciary to the post of district judge is involved. The interview is the best method of judging the performance over personality and actual working knowledge and capacity to perform. Otherwise, the standard of judiciary is likely to be compromised. A written examination only tests academic knowledge, which is sometimes gained without possessing overall qualities, practical experience of practice and law. In written exam, even the person who with no caliber who takes decision by cramming may obtain better marks. When the judges of the High Court too are appointed by judging the performance and intellect, an interview would be indispensable for judicial post, as ultimately they also come to adorn the chair of a judge and judges of subordinate and higher judiciary to deliver justice to masses. The criteria of experience of practice for direct recruitment of 7 years, whether actually gained, can be adjusted only by interview, communication skills, and by elucidation of certain aspects which would not be possible by written exam alone. In Shiraj, it was emphasized that interview is the main fulcrum for judging the suitability of the candidate for appointment as district judge in the higher judiciary. In our opinion, that is absolutely necessary. When we consider past practice earlier, when the written examination was not prescribed, the High Court used to select candidates for higher judiciary only by the method of interview. Now additional safeguards of written examination have been added. The importance of interview for the post of higher judiciary has increased than ever before. It is absolutely necessary to weed out unworthy element primers, and in our considered opinion, it is not only appropriate but also absolutely necessary to prescribe the minimum pass mark so as to weed out unworthy element, so as to segregate grain from chaff. There is a vast difference between having the experience that is required for a judge that cannot solely be a judge on the basis of written performance, and for which overall personality, intelligence test is absolutely necessary. Without that, it would not be appropriate to make appointment in judiciary. Thus, in our opinion, the prescribed minimum 45% mark for reserve category candidate could not be said to be uncalled for, merely by the fact that some more posts were advertised and they are lying vacant. It could not have been a ground to relax the minimum mark for the interview after the interview has already been held. It would not have been appropriate to do so, and the High Court has objected to relaxation of minimum passing mark in viva voce examination in its reply. As the power to relax is to be exercised by the High Court, and since it has opposed such a prayer on reasonable ground, the institutional objective behind such prescription, we are not inclined to direct the High Court to relax minimum marks. Finally, my lord, para 21.
Yes.
Even otherwise, the petitioner have undertaken the examination with the stipulation of minimum cut-off marks in written, oral, and then having failed, they cannot turn around and are a step to contend to that contrary. This court, Shiraz, my lord, again, my lord, the
No, that's
relevant
been
paragraphs of Shiraz.
So first couple has been considered.
Yes, my lord.
Various other judgments are also cited.
Then, my lord, there is a judgment, 2016, 10 SCC, 484.
Mhm.
Party's name is Salam Samarjit Singh versus.
High Court of Manipur. So
Yes.
This is of the contemporary date.
Yes, my lord.
Yes.
The relevant paragraphs, my lord, will find para 22, it starts.
This was referred to a larger bench.
Yes. this
What has
was,
happened?
my lord, till now I have checked up, nothing has come out.
Mhm.
But law has been laid down at para 22 onwards, my lord.
22. In spite of the reference.
Look, reference is there, but the reference is not with regard to this
Let's
Well, what-
let's read.
para 22, my lord.
Yes.
After referring to Manjushree and Himani Malhotra in Ramesh Kumar versus High Court of Delhi, it was also held as under. Thus, the law on the issue can be summarized to the effect that in
This-
case,
Yes.
in case the statutory rule prescribed a particular method of selection, it has to be given strict adherence accordingly. In case no procedure is prescribed by the rules and there is no other impediment in law, the competent authority, while laying down the norms for selection, may prescribe the test and further specify the minimum benchmark for written test as well as viva voce. My lord, this is the para
This is
15
Ramesh
of
Kumar.
Ramesh Kumar
Ramesh
that has been relied by the petitioner. Ramesh Kumar has been relied by the petitioner. My senior has read para 18.
Hmm.
My lord, the ratio is at para 15.
Para 15.
In Ramesh Kumar itself, at para 15, the Honorable Apex Court has said, if there is no impediment, my lord, the competent authority can prescribe minimum cut-off mark in written as well as in viva voce, my lord.
Yes.
Then my lord will kindly have para 23
Of
of this.
this judgment.
Yes, this is.
Yes.
Both Himani Malhotra and Ramesh Kumar relied upon Manjushree to hold that prescription of minimum marks in the interview was not permissible after the written test was conducted. After referring to state of Haryana versus Subhash Chand Marwaha, and observing that principles laid down in Manjusri without any further scrutiny would not be in the larger public interest or goal of establishing an efficient administrative machinery in Tej Prakash Pathak versus Rajasthan High Court. This court observed that the matter deserves consideration by a larger bench. In para 12 to 15, it was held as under. The para 12 and 15, 12 to 15 of Tej Prakash
Prakash.
Pathak,
Yes.
that has been incorporated. I'll just like to take para 14 of that in the next page, Milord.
Yes, yes.
Unfortunately, the decision in Subhash Chandra Marwaha does not appear to have been brought to the notice of their lordships in Manjusri. This court in Manjusri relied upon P.K. Ramachandra versus Union of India, Umesh Chandra Chukla, Union of India, Durgacharan Mishra, State of Orissa. In none of the cases was the decision Subhash Chandra Marwaha considered. No doubt it is a statutory principle not to permit the state or instrumentalities to tinker with the rules of the games insofar as the prescription of eligibility criteria is concerned, as was done in C so and so, in order to avoid manipulation of the recruitment process and its results. Whether such a principle should be applied in the context of the rules of the game stipulating the procedure of selection, more particularly when the change is sought to be imposed, a more rigorous scrutiny for selection requires an authoritative pronouncement of the larger bench of this court. We therefore order the matter to be placed before the Honorable Chief Justice for appropriate orders in this regard. Since the decision laid down in Manjusri is doubted and the matter is pending for consideration by a larger bench, and in the facts and circumstances of this case, it is my view that the ratio laid down in Manjusri and Himani Malhotra is not applicable in the present facts, in the present case. This court has laid much emphasis on interview stroke viva voce in a catena of decisions. In the recruitment of judicial service, the importance of interview viva voce cannot be undermined. Viva voce is the best mode of assessing the suitability of the candidate as it brings out the overall intellectual qualities of the candidate. Again, Milord Ramesh Kumar has been quoted. Para 25, next page.
Yes, full court decision.
Yes, the full court decision dated so and so prescribing minimum qualifying mark for viva voce is a decision taken towards ensuring the fair and meritorious appointment on the post advertised, and no mala fide can be attributed to the respondents for such a decision. Had the High Court convened the full court meeting after conducting the viva voce and had then prescribed the minimum qualifying marks, the contention of the petitioner would have been justified. When the decision of the full court was to ensure selection of meritorious candidate, it cannot be said that the decision of the High Court amounted to change in the criteria of selection after the selection process has started. The petitioner contends that the decision of the High Court to prescribe minimum qualifying marks is against the recommendation of the SETI Commission and is violative of judgment of All India Judges Association so and so, so and so. It is further argued that in the said case, the court accepted the SETI Commission's report, which has recommended not having cutoff mark in the interview for the recruitments of the judicial officers. No doubt, the SETI Commission has recommended in its report that there should be no cutoff mark in the viva voce test. Relevant recommendation of the SETI Commission rests as under. The viva voce test should be in a thorough and scientific manner, and it should take.
Mr. Nath, issue, this is a view of the learned single judge.
True, my lord.
And the other judge, other honorable judge disagreed. So
Yes.
this can't be a ratio of the judgment.
My lord, what I'm trying to, my lord, submit is that there is no quarrel between the two judges with regard to whether there should be a cutoff mark in interview and written.
On what
test.
issue has it been referred? Read the dissenting view of Justice S.K. Singh. Please read.
Yes, my lord.
Now, this is precisely on the minimum marks.
Yes.
This is precisely on the minimum marks.
I'll just take your lordship. my lord.
Yes.
Here, the issue has been of changing the rules of the game.
In the midst of the
In the
process.
midst.
Yes.
Yes. So in that page 88, my lord. Inter alia, it was also indicated as in the position in the rules that for being called for viva voce test, a candidate must secure in the written examination 60% mark if he is from unreserved category and 50% marks for reserved category. The viva voce carry 50 marks. The examination was held on so and so. Then
So
my
that
lord,
was, the view was taken because this criterion was introduced a later part after the selection process.
exactly, my lord. In that context, my lord, difference was there. Otherwise, so far as it is, my lord, cutoff mark in written, my lord, written and viva voce or interview is concerned, my lord, there is no dispute with regard to that fact.
Yes. All right.
Then I am relying on, my lord, Tej Prakash Pathak, my lord, of Rajasthan High Court
Hmm.
versus Rajasthan High Court,
Yes.
2013 4 SCC 540. You'll also will find page 94. I'm just giving the relevant paragraphs, my lord.
Please do.
2, 4, 5, and 15, my lord. This is basically on, my lord, rules of the game.
Changing the rules of. the
Rules
game.
of the game, my lord.
Hmm.
And the decision of this honorable court, my lord, in the division bench.
Hmm.
2022 SCC online Guwahati 1426.
What has been discussed in that then?
Yes, my lord.
It relates
The-
which recruitment?
My lord, this
This
is with
relates-
regard to grade 1 recruitment pertaining to state of Nagaland, my lord.
Of which year?
Of this recruitment was initiated. Advertisement was initiated
2018.
2018, my lord.
Yes. What has been held?
My lord,
Read please.
Relevant paragraphs. Para 19,
Yes.
20, 21 and 2021.
Hmm.
Para 19, my lord.
Yes.
The learned counsel for the respondent number 1, 2, and 3 has argued that the purpose behind prescribing cutoff mark for written test as well as viva voce was to ensure that only the suitable candidate were appointed as judicial officer. The above submission of Mr. So-and-so finds due reflection in the rules of 2006 as well. The plain reading of the general instructions contained in Schedule B of the rules of 2006 clearly indicate that the recruiting agency should have the discretion of prescribing criteria for selection. The relevant portion of the general instruction contained in Schedule B of Rule 2006 is extracted for the ready reference, my lord.
Hmm.
Then the general instruction, my lord, it has been quoted. The object of viva voce examination under sub-rule 1 and 2 is to be assess the suitability of the candidate for the cadre by judging mental alertness, knowledge of law. Same, my lord.
In that case, they viewed, the division bench held that the advertisement was not under challenge.
Yes, my lord. Advertisement was not
Herein
under
there is a
challenge.
specific prayer of the petitioner.
And my lord, another issue, it has been held that the rules, when there is the object in the rules
Yes.
for selection has been explicit,
Hmm.
it
Hmm.
clearly reveals that the rules confers the power
Yes.
to prescribe the cutoff mark. That has been held referring to Siraj at
Right.
para 21, my lord.
Okay. Okay. Uh, Did you try to find out whether this judgment has been challenged any further?
This
This division bench judgment,
As
yes.
of now, my lord, there is no challenge, my lord. I have
No
checked.
challenge? You
Yes.
checked?
I have checked in the Supreme Court website, my lord.
Website. Okay.
As of now, there is no challenge.
Right. Okay. Yes. Anything else?
My lord, only I'm just giving the page numbers
Yes.
of, because the ratio laid down by Siraj and the procedure followed by this honorable court, my lord, has been followed pan India in all other high courts, my lord. I have annexed some
High Court judgment.
judgment of high court also, my lord,
Hmm.
that your lordship will find in the compilation serial number 9 and 10.
Yes. Madras High Court.
Yes, Madras High Court and Bombay High Court, page 150 to 164. I'll just give the para numbers, my lord.
Yes. to that.
In so far as, my lord, serial number 9, that is Madras High Court, it's a 2022 judgment, my lord.
Hmm.
I'm referring to, my lord, para 22, 23, 28, 31, 33, 34, and 39.
Right.
And so far as the High Court of Bombay is concerned, my lord, I'm referring to 26, para 27, 28
Of which judgment?
of, my lord, serial number 10, lordship will find in the index.
Brushali versus.
Yes, Brushali Vilas Pushekar versus Maharashtra Public Service Commission.
Right.
Here, my lord, paragraphs will be paragraph 26, 27.
They are basically all founded on Siraj.
All founded
They are
on
all
Siraj.
founded
My
on
lord, all along, all over India, Siraj has been followed, my lord.
Yes.
Since in Ramesh Kumar, my lord, the petitioner referred to and tried to give a different view. But Ramesh Kumar's ratio is not in para 18. Ramesh
in para
Kumar's ratio
15.
is para 15, my lord. And so far as the other judgments relied on by petitioner is concerned, my lord,
Yes.
all those judgments are, my lord, divergent in facts, my lord. Mainly rules of the game, that is the factual background. And in that context, my lord, the decisions of the Honorable Apex Court had come. Not in the instant issue, my lord. Instant issue, constantly, my lord, the law laid down by the Honorable Apex Court is, my lord, the same. So in that view of the matter, my lord, my humble submission is that, my lord, the High Court has not done anything wrong in prescribing, my lord, cut-off marks in the interview. We are to select the best person for the post so that the society can be served, well served. So in that view of the matter, my lord, there is no merit in the writ petition, my lord. The writ petition, my lord, deserves to be rejected, my lord. Much obliged.
Yes.
Let's say government interview.
Yeah, for the respondent number 6,
My lord, 5 and
the
6.
selected candidate.
5 and 6.
Yes,
I'll
please.
take 5-10 minutes, my lord.
No, you free to take as long as you want.
Very well.
Your client's jobs are at stake.
Would not be, my lord. That's going to be my submission. In fact, there is no threat. Be that as it may, my lord, I just make two things clear at the very outset. Both respondent 5 and 6 were appointed on 17th of May 2016. They were appointed. Respondent 5, Lobsang Tenjing, presently he is the topper. If we take into consideration the plight of the petitioner,
Yes.
and Gote Mega comes thereafter. Respondent 6.
Yes.
So assuming, my lord, if the contention advanced by my esteemed colleague is accepted by my lord, Lobsang Tenjing would not be affected, but Gote Mega will be, respondent 6.
Respondent number 6. So whose
Yes.
name has been deleted? There is a deletion of name. Whose name has been deleted?
No name.
There is one deletion. We find it. Respondent number 7.
7. I'm not.
Okay.
Now, my lord, I deal with the law straight away.
Yes.
As I understand it.
Please.
Now, my lord, there are two lines of cases. There are two lines of cases. The first category belongs to those very cases wherein the advertisement laid down the requirement of securing minimum marks
Yes.
and the rules were silent. I would not use the expression quote unquote deviation from the rule. I would say rules were silent and the advertisement laid down requirement of securing minimum marks.
Yes.
So far as, my lord, this category is concerned, there are 3 cases on the subject. The first first 2 cases have been referred to, namely, number 1, K.S. Siraj versus High Court of Kerala, 2006 SCC 395, and the second is Tanya Malik versus the High Court of Delhi, 2018 14 SCC 129.
Yes.
Apart from these 2 cases, my lord, there is a third case also, Mahinder Kumar versus the High Court of Madhya Pradesh, that is 2013 11 SCC, page 87. I'll
Yes.
refer to some of the paragraphs of this very particular judgment because it has not been referred to.
Yes, please.
Now, my lord, this is so far as the first line of cases are concerned. And my lord, my submission is, so far as the present list before my lord is concerned, it is squarely and exclusively and completely governed by the first line of cases. The second line of cases pertain to a situation wherein the requirement of minimum marks in the interview was laid down after the written test was conducted. I'm sorry. So, my lord, second line of cases pertain to the situation wherein the requirement of minimum marks in the interview was laid down after the written test was conducted. So far as, my lord, this line is concerned, is K. Manjushri versus the state of Andhra Pradesh, 2008 3 SCC 512. Hemani Malhotra versus the High Court of Delhi, 2008 7 SCC 11, and Ramesh Kumar versus the High Court of Delhi, 2010 3 SCC 104. These are the leading cases. My lord, my submission is that so far as second line of cases are concerned, they do not govern the subject. They do not govern the field. So therefore, my lord, no reliance should be placed on these cases.
Right.
Now, my lord, even the view which is taken in the second line of cases, the correctness of the view was doubted by the Honorable Supreme Court in Tej Prakash Pathak. My Lord Justice Chalameshwar. What he called the cliche, quote unquote, laying down the rules when the game is played. He said, no, this view does not appear to be correct. And the correctness of the view in the second line of cases was doubted because my Lord Justice Chalameshwar was of the opinion that the Marwaha case was not there before the Honorable Supreme Court. And my Lord, it is the correctness of the second view which is for the consideration of the larger bench. These three cases are Tej Prakash Pathak versus Rajasthan High Court, 2013 4 SCC 540. Number 2, Salam Samarjit Singh versus the High Court of Manipur, 2016 10 SCC 484. And number 3, Shivanandan CT versus High Court of Kerala, 2018 1 SCC 239. So my Lord, my submission is that so far as second line of cases, even the view taken therein is subject to the consideration of a larger bench. So far as the present list is concerned, we are squarely governed by the first line of cases.
Yes.
So my Lord, there is no difficulty whatsoever. Now, my Lord, there is another aspect of the matter that contention has been advanced that look, the Shetty Commission's recommendations are binding. Now, my Lord, so far as Shetty Commission's recommendations are concerned, they were accepted by the Honorable Supreme Court in All India judges cases. Now, over there also the view is divided. So far as Justice Bhanumati is concerned, she pointed out in Salam Samarjit Singh versus the High Court of Manipur that All India judges case, it is sub silentio. So far as recommendation of Shetty Commission as to no cut-off box for Viva be there is concerned. My Lord, that is paragraph 28. I just read that. This is the view taken by the Honorable Supreme Court. At least, my Lord Justice Bhanumati has taken that view, subject to the consideration of larger bench. And my Lord, I have not come across any judgment of the Supreme Court where it has been categorically held that the Shetty Commission's recommendation insofar as no cut-off mark for Viva proposition has been explicitly accepted by the All India judges case. There is no judgment on the point.
Okay.
Now, my Lord, Salam Samarjit Singh, 2016 10 SCC 484. What have you given?
Page.
My Lord,
Para.
I'm sorry, I'm dealing with it. 2016 10 SCC 484, the relevant para 28.
Yes.
28, my Lord, I read this. In fact, my Lord, the exact observation is at placitum C in para 28, but I read the entire paragraph. Admittedly, the Shetty Commission has recommended that the Viva Voce test shall carry 50 marks and there shall be no cut-off marks in the Viva Voce test. In All India Judges Association case, para 37, this court subject to various modifications in the judgment accepted all of the recommendations of the Shetty Commission. While there was a detailed discussion on the paths, mode of recruitment to the higher judicial service, and the proportionate percentage for promotion as a district judges for judicial officers, limited competitive examination for civil judges, junior division, and percentage of direct recruitment, there was no detailed discussion regarding the other recommendations of the Shetty Commission. As rightly contended by the London Senior Counsel for the respondent, All India Judges Association case is sub silentio on the recommendation of Shetty Commission as to quote unquote no cut-off marks for the Viva Voce. The contention of the petitioner that fixing cut-off marks for the Viva Voce is in violation of the decision of this court is not tenable. Now, my Lord, this is the view of my Lord Justice Bhanumati in Salam Samarjit Singh, and there is no authority to the contrary. I could not lay my hand on any proposition, my Lord, anywhere. In fact, my Lord, I went through All India Judges case and I did not find any line from where, my Lord, I could decipher that, yes, court took that into consideration. So, my Lord, it is sub silentio on that sub point. Now, my Lord, I'll straight away come to the third decision, which I refer to the first line of cases, because, my Lord, my submission is, so far as second line of cases are concerned, there is no requirement to mention to those cases. They are not applicable at all, so far as the present dispute is concerned. I'll deal with, my Lord, the Mahinder Kumar versus the High Court of Madhya Pradesh, 2013, 11 SCC, page 87. Page 87.
Yes.
My Lord, paragraph 34 to 37, I will deal with. because here, the Honorable Supreme Court spoke of Article 233. We have the High Court has the power. Rules may be silent. I read from 34 to 37. Page 105. Mahinder Kumar. Article 233, clause 1 specifically states that the appointment of persons to be made, as well as the posting and promotion of district judges in any state, can be made by the governor of the state in consultation with the High Court, exercising jurisdiction in relation to such a state. In other words, while the governor of the respective state is the appointing authority of the district judges, the selection for such appointments, as well as the subsequent aspects, namely postings, promotions, etc., of the district judges, are to be determined by the High Court in respect of the state concerned. When such being the constitutional mandate, which empowers the respective High Court to deal with the selection of district judges within its jurisdiction and the ultimate appointment to be made by the governor of such state concerned, a reading of Article 233, Clause 1 of the Constitution, along with Rule 7 of the 94 rules, without pausing here, I clarify that so far as Rule 7 of the 94 rules herein are concerned, the rules only said the High Court can frame its own procedure, can formulate its own procedure. So Rule 7 gave a very wide power. To that, I would say that here the rules are silent. Clause 3 is also there, which speaks about the suitability. So, my lord, harmoniously, if we look into the rules, my lord, there is no prohibition so far as full court resolution, because full court resolution is there. It's in conformity with Article 233, Clause 1 of the Constitution. So that has to be read within the rule itself. And here, my lord, the advertisement was very clear. They had the notice, they knew what is going to be the procedure. No one objected to that. They took their chance. When they found that, look, they are not making it, they came before the court after the results were declared. So Rule 7 of the 94 rules is amended in the year 2005. It will have to be held that the first respondent High Court is invested with every power and authority to evolve an appropriate procedure in the matter of selection for direct recruitment and promotion of entry-level district judges, and that depending upon the exigencies, such procedures can also be specified by the first respondent High Court from time to time. Therefore, we have no difficulty in holding that the first respondent High Court was fully empowered under Rule 7 to prescribe the required procedure for selection of the entry-level district judges by way of direct recruitment and specify such procedure from time to time according to the exigencies prevailing. In this background of the rule prevailing, when we examine the prescription contained in para 9, subpara 4 of the advertisement dated 21/8/2006, we must state that such prescription contained therein empowering the High Court to decide which of the candidates can be called for the interview based on the evaluation of their performance in the written examination should also be held to be in consonance with Rule 7 and Article 233(1) of the Constitution. Once we steer clear of the said position, the next submission of the learned senior counsel for the petitioner was that when assuming Rule 7 empowers the High Court to follow its own procedure, it should have been disclosed in the advertisement. The contention of the learned senior counsel was that whatever procedure evolved by the High Court should have been disclosed well in advance by the High Court, or at least before the written examination was conducted. When we considered the said submission, we find that there is a clear indication in para 9 of the advertisement as to in what manner the High Court is going to conduct the selection process. So, my lord, this is what the Mahinder Kumar is. So therefore, my lord, and here also, my lord, the Ramesh Kumar was referred, of course, in a different way. But my submission is Ramesh Kumar has no application because in any case, the very subject matter of Ramesh Kumar was requirement of minimum marks in interview was laid down after conduct of the written test. So therefore, my lord, my submission would be, my lord, in fact, the rules are, clause 3 is very clear of the rules. It is to be seen and read holistically, in conformity with the full court resolution. The full court resolution is, my lord, is in conformity with the exercise of power under Article 233, Clause 1 of the Constitution. And here, my lord, we are selecting district judges. Interview is of great significance. In this connection, my lord, in Tania Malik itself, the Honorable Supreme Court emphasized the importance of interview. I need not refer to those paragraphs because it has already been para 18 and para 19. Para 18 and para 19 of Tania Malik, the importance of interview and need of prescribing minimum mark for the same in the case of judicial officers. I think it is, my lord, Justice Tanya Malik. Yes, Justice Arun Mishra, my lord.
Yes.
Judgment is authored by Justice Mishra, and in para 18 and 19, his lordship has emphasized upon the importance of interview and need of prescribing minimum marks for the same.
That
in
is
case
a
of judicial
reiteration of
officers.
case Siraj, nothing other than that.
So that's it, my lord. Siraj,
Yes.
Tanya Malik, and Mahinder Kumar. My lord, that's the
Yes.
ratio. My lord, I hope. Good night. That's all, my lord. Nothing else.
I'll give, nobody has bothered to look at clause 6, which we pointed out to Mr. Chaudhary.
Yes, that's
Yes.
it. That's
Yes, that is there in the
it.
rules.
Also,
Short reply, my
six.
lord.
Mm.
Yes. My lord, my friend Mr. Das, appearing for the High Court, my lord, he never advanced any argument on the purport of the rules. He was only referring to that Roman 3 regarding how
We have,
suitability.
we have gone beyond that. We have asked you
No, my lord,
clause 6 as a
absolutely.
clear indication
Yes.
of objective grade value exercise.
No, my lord, there is no difficulty.
Similar,
No, my lord.
similar, that means similar to the written examination.
Yes,
And written examination, there is a prescription of minimum marks.
yes. Now, my lord,
Yes.
before I make my reply submission, I'll just have your lordship's attention to the rule for a moment, my lord.
Yes, please.
Please come to page 8, my lord. Please come to the bottom portion,
Yes.
general instruction 3. Selection of candidates shall be made on the basis of cumulative grade obtained in written and viva voce examination. This is the mandate of the rules. A candidate will be selected based on aggregate marks secured in or obtained in written test and viva voce. Now, my lord, in the background in which the rule has been framed, can we read, my lord, clause 3 in isolation and to give a meaning?
You just, Mr. Chaudhary, give answer to one situation.
No, my lord.
Just hold
Yes.
on, sir.
Yes.
You just give an answer to one situation. There's a written examination wherein 300 marks, total grade, gross marks are 300. The result is declared, one candidate secures 230 marks. The interview marks are 50. All right. There is no prescription of minimum. The next candidate secures 180. So there is a gap of 150. Now this candidate who secures 230 says, forget about your interview, I'm not appearing. What is the answer? You'll still have to be selected because there is no minimum marks. Give him 0. What difference does it make?
No, my lord.
Is this the intention of the rules?
No, certainly not.
Then-
The example.
How is
No, no.
it to be checked?
I'm coming
Let
to
us
that. The example which your lordship has given is a plausible example. In a
That
given
is, that was a
situation-
situation, we'll tell you, that was a situation which we faced in Rajasthan. That there were candidates who were tight-lipped. Maybe they might have been instructed, don't give any answer. You can't fail because you have enough of a cushion in your written
My
examination.
lord, in those situations, certainly, my lord, High Court won't be powerless. High Court can certainly
Under what,
devise some
sir,
procedure.
under what power?
My lord,
Under what power? After the advertisement
No, if-
doesn't have any
no,
condition?
no, if such a situation arises,
Yes.
certainly, my lord, High Court won't be powerless. But
Tell
in
us,
normal
from these rules, which power is there with the High Court?
or High Court may also re-advertise the post.
Ah, that's good.
May-
That's a
may-
good idea.
They
Yes,
re-advertise. Now, finally, come to page 9.
yes.
The object of the viva voce examination is to assess the suitability of the candidate
Yes.
for the cadre by judging the mental alertness, etc., 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 etc. My learned friend, Mr. Das, urged mainly on this.
Yes.
And Siraj and all the judgment he has relied to show that, in fact, this viva voce component is significant, therefore it cannot
Is
be ignored.
More
Well,
significant.
nobody is disputing their proposition.
Yes.
Well, the decision is an authority for what it actually decides. Now, please come to my learned friend also made a submission that in Ramesh Kumar, I did not refer to para 15. I referred to only para 18. No, I read para 15, 16 and 18. Para 15 and 16 for the proposition which I am trying to advocate and para 18 for the proposition that even if I participated, no
I'm not
equity-
precluded.
Yes, I cannot
from
be
challenging.
precluded from
There is
challenging.
no stop.
He is not correct therefore. Now, my lord, let us, please, I'm referring to one judgment, my lord. AIR 1968 Supreme Court AIR 1968 Supreme Court 647. This is, my lord, State of Odisha versus Sudhanshu Shekhar Mishra. My lord, here I'll rely upon paragraph, my lord, 13.
Yes.
Yes, my lord, I am placing the judgment for the proposition. A decision is an authority for what it actually decides. Any observation is not a ratio decision.
Yes.
Only for that proposition.
Yes.
Page 651, just before the, my lord, subpara, sentence about 1, 2, 3, 4, 5, 6, 7, 8 from the bottom of the first subpara, my lord. A decision is only an authority for what it actually decides. What is of essence is a decision is in its ratio, and not every observation found therein, nor what logically follows from various observations made in it. Now, let us, my lord, having regard to this observation of the Supreme Court, let us find out, my lord, what was the situation in Siraz? Because whole and soul of High Court was Siraz. Please come to para 11 of Siraz, my lord, in my paper book, my lord. I deliberately did not place it. I know he will place it. That's why I compiled it in my compilation, my lord. Page 116. What was the situation in Siraz? And what is the situation here?
Yes. Yes.
Kindly see, my lord, para 11.
Yes.
Kerala Judicial Service Rule 1991, hereinafter referred to as the rules, were made in exercise of the power conferred by Article 234 and 235 of the Constitution of India and subsection 1 of Section 2 of the Kerala Public Service Act. Rule 7 reads as thus: preparation of list approved candidates and reservation appointment. High Court of Kerala shall from time to time hold examination, written and oral, after notifying probable number of vacancies to be filled up, and prepare a list of candidates considered suitable for appointment to category 2. The list shall be prepared after following such procedure as High Court deems fit and by following the rules relating to reservation of appointment. How a decision, how an observation made in such a context can have any bearing in the decision which Lordships is, called upon to decide. My utmost respect, I'll submit, my lord. Siraz was a judgment in these facts. Here, my lord, every authority was given to the High Court to devise this process of selection. No, it is not like that. Here, my lord, and a candidate will be selected based on aggregate of written and oral.
Yes.
In such a situation, whether Siraz will come to the rescue of the High Court. With greatest of the respect, I'll submit, my lord, the judgment cannot have any bearing on adjudication of the issues involved here.
Very well.
Then, my lord, will kindly come to the other judgment. Though, my lord, there is a dissenting view also, because they refer to the view of Justice Vanuvati, my lord, in this 2016-10 SCC.
Yes.
Please come to, my lord, page number 488.
Yes.
Let us see, my lord, what was the facts in that case. Para 5. The petitioner appeared before the interview committee comprising of the Chief Justice and 2 other judges of the High Court of Manipur on 12 to 15. In the interview, the petitioner obtained 18.8 marks out of 50 marks, that is 37.6%. Since the petitioner failed to secure minimum marks of 40 prescribed by notification dated issued by the High Court, the petitioner was declared not selected. Aggrieved by the aforesaid notification, petitioner has filed the writ petition. Now, please come to para 8, my lord. The case of the respondent High Court is that the entire selection process of 2013 examination has been conducted in a just and a fair manner, following the rules prescribed under Manipur Judicial Service Rule, and the action of the respondent is not violative of Article 14 and 16 of the Constitution of India. This is important. Schedule B of the Manipur Judicial Service Rule prescribed minimum qualifying mark for viva voce. Additionally, my lord, it is the case of the respondent High Court that minimum qualifying mark prescribed have been further clarified in the full court resolution that it stands.
Yes.
So, my lord, how this judgment will help them? Here, my lord, the minimum qualifying mark was prescribed in the rules and it was 40%. And the candidate secured only 37.6. It was in this factual background, my lord, the observation is made. Therefore, my lord, it is very important to keep in mind that decision is an authority for what it actually decides. Now, my lord, a decision rendered on these facts will have any bearing in the present case. Therefore, my humble submission is, my lord, yes, my learned friend Tiwari is correct. The judgment, some of the judgments which I have referred, where, my lord, the rules of the game were changed in between. But nevertheless, my lord, the common thread which was running through the judgment was the SETI Commission's recommendations has been accepted by the Honorable.
His argument is that the recommendations, no judgment refers to the recommendation qua minimum marks in Viva Voce.
Okay,
His
my lord.
argument.
Then the answer is, my lord, please come to para 46 of my compilation.
Yes,
Para 46,
yes, please.
page 46,
Read.
para 18.
Yes.
After quoting that SETI Commission recommendation, this court notices that in All India Judges Association versus Union of India, subject to various modifications indicated in the said decision, the other recommendation of the SETI Commission were accepted by this court. It means that prescription of cutoff mark at Viva Voce test by respondent was not in accordance with the decision of this court. It is an admitted position, both the petitioner, so my lord, this is the clear sentence.
Yes.
It's a clear sentence. There is one more, my lord, that in the Himani Malhotra's, sorry, there is one more observation. If your lordship should kindly come to my lord.
Mr. Chaudhary, please read Siraj again. What you are referring to Schedule B, it doesn't prescribe any minimum marks for Viva Voce. You are mistaken.
My lord.
Schedule B, which is referred to in this Siraj, nowhere
I'm not
nowhere
referring to
prescribes.
Siraj doesn't say, my lord.
You say Salam Samarjit Singh. It doesn't say minimum marks, sir. Doesn't
Where?
say. Read the judgment properly.
No, my lord, I read para 8.
No, sir. You
Para 8, para 8.
read para 10, 11, 12, 13, 14. Schedule B is reproduced.
1 second, my lord.
That is the case. That was the argument of the High Court. The Schedule B is just at par with the schedule here, which we read out.
No, my lord,
That is
High Court's contents.
cumulative.
No, my lord, High Court's contention.
Read, please.
Okay, para 10.
Para 10.
We have heard the learned counsel for the parties at length. Learned senior counsel for the so-and-so submitted that full court minimum 40% in the interview.
That is precisely based on clause 6, which we refer to. That is what the argument is, that you can't fix a minimum marks on the basis of those instructions for evaluation.
My lord, in any
Read anyhow, carry on.
Yes. The learned senior counsel for the writ petitioner Sanjay R. Hagre submitted that the full court resolution dated so-and-so fixing cutoff mark minimum 40% in the interview is erroneous interpretation of the evaluation of performance given in Schedule B of the Rule 5. It was further submitted that action of the respondent to apply the criteria of minimum qualifying mark in the interviewed amount to change in the criteria of the selection after selection process started. It was further submitted that the petitioner never informed about the resolution dated so-and-so, obtaining the so-and-so. Per contra, the learned counsel for respondent has submitted Schedule B of the rules stipulate minimum qualifying marks cumulatively both for the written and Viva Voce. And the said minimum qualifying marks so prescribed by the rules were further clarified in the full court meeting dated so as to avoid any discrepancy during the Viva Voce conducted by the interview committee. It was submitted that the Manipur Judicial Service rules clearly stipulated that all necessary steps be not provided for in the rules for recruitment shall be decided by the recruiting authority. And while so, the full court so-and-so. So, my lord, there was a clear stipulation that in case there is any, there is no clarity on any point, then recruiting authority will be given the thing. My lord, here, my lord, it is reiterated that the Schedule B says that.
No, that is the argument. That is the argument.
Okay.
Whereas schedule is reproduced here. That is the same clause 6, which we pointed out. The same clause is being read. That is what is being read. That this interpretation of clause 6 is incorrect. You come to page 491.6. That is what the schedule is.
491 clause A.
Yes.
What happens is that.
Exactly the same clause
Yes.
which is here.
No,
From
what happens-
from that clause, this power was derived.
No, my lord, here there is no rule like in our case. In our case, there is a
Is-
clear rule.
Verbatim the same, sir.
No. That's the part of the.
In
rule. I'm not
Manipur.
disputing- No, I'm not, maybe I'm not clear to yourself.
Yes.
My lord. What I'm trying to submit is the Manipur Judicial Service rule does not contain any, my lord, bar. There was no bar in the Manipur rules. On the contrary.
So where is
this
the bar in
sentence-
our rule, sir?
Hmm?
Where is the bar in
Yes,
Arunachal? Yes.
in my humble understanding, there is a clear bar. Then,
Sir,
my
the
lord, what
rules-
meaning we give to
rules
this?
are verbatim the same, Mr. Chaudhary.
No, my lord. Can you
Yes.
see, selection of candidates shall be made on the basis of cumulative grade obtained in written and viva voce examination.
Yes.
So lordship
Same.
have to give a meaning to this.
Of course, that's true.
This is the, if your lordship gives an interpretation that this rule can be interpreted to mean that minimum of the, in the viva voce can be fixed. That's a different issue. But my humble submission is, my lord, prima facie, the selection can be made based on cumulative grade. There is not, and my lord, no, my lord, even in this Salam Samarjit's case, Singh's case,
Yes.
there is a provision in the Manipur rules which says all that necessary steps not provided for in the rules for recruitment shall be decided by the recruiting authority.
Yes.
My lord, here in this case, the full court decision is of, my lord, 8/6/2012, where there was a recommendation for amendment of the rules.
Yes.
Before amendment of the rules could have been done, my lord. That I think I'm not, my lord.
Read clause, rule 12 of the rules of Arunachal Pradesh. Rule 12, page 4.
Okay. No person selected for appointment by Director Approval shall be appointed unless appointing authority is satisfied that he possesses so unless is certified by medical authority. Condition relating suitability, fitness, and character.
Suitability. So even
Yes.
after selection, the
Yes.
suitability can be tested by that.
For a moment, I am not disputing all these things, my lord.
So what you are
Only
saying,
my-
the power of the recruiting authority,
Yes.
which is there in Manipur rules, is very much there in these rules also.
My lord, the Manipur rule, full rule is not before us, my lord, in any case.
Yes.
But Manipur rule is slightly different. Yes, certain
Anyhow,
clauses are there.
Yes.
Anyway, I'll not detain your lordships any further, my lord.
Yes.
To, my lord, summarize my arguments, my lord. The High Court's reliance on Siraz and this Samarjit is of no avail because those were rendered in absolutely different circumstances.
Very well.
Even in Samarjit, my lord, there was a minimum mark was fixed by 40%, and it was also fixed by the full court in addition to the rules. Secondly, my lord, in Siraz, there is nothing like that. Siraz, there was no rule. In fact, the entire authority was given to the High Court. And certainly, my lord, how can I dispute the proposition laid in Siraz that interview is one of the best way to judge the suitability of a person? There can be no manner of doubt.
Yes.
My lord, in fact, my lord, in that judgment of the Supreme Court after Ajay Hasia, there was just in the same year, there was a judgment, I forgot the name, when for the first time the Honorable Supreme Court said, my lord, distinction was brought out between interview for admission to educational institution and admission to, my lord, for recruitment. Sorry, viva voce for the purpose of recruitment. Where in case of admission into, my lord, educational institution, it was said the interview components should be kept to as minimum as low. Therefore, it was in Ajay Hasia, it was said 15%. But when it comes to, my lord, recruitment to public service, interview was considered to be one of the most suitable method for selection because it, my lord, the objectivity is there. Therefore, my lord, it is better to judge.
Right.
Now, in the context of the Arunachal rule, whether, my lord, that view can be taken, that is the
That
issue.
is for this.
In my humble submission, my lord, it cannot be because the rule is very clear.
Yes.
And the rule prescription, even, my lord, that judgment of Ramesh Kumar at para 15, just I'll conclude by reading that sentence once, my lord,
Yes.
at page 71 of my compilation.
Yes, please.
Thus, the law on the issue can be summarized to the effect that in case the statutory rule prescribe a particular mode of selection,
it has to be given strict adherence accordingly. In case no para 15, my lord, because my learned friend was saying that para 15 lays down the law. In case no procedure is prescribed by the rules, there is no other impediment in law. Competent authority, while laying down the norms for selection, may prescribe for test and further specify minimum benchmark. So second part will come only when there is no rule. Since rules are there, therefore in my humble submission, my lord, the selection could have been made only by strict adherence to the rules and not by any other method.
Yes. Very well. All right. Arguments are judgment. Well, now we can start the criminal matters. Transfer matter, the council is here. Yes. Yes, gentlemen.
My lord, I have instructions that the appellant is ready to go anywhere. If he is transferred in strict adherence to the rules. my lord.
So you mean to say you want an order on merits? We'll decide that then. All right. What do you say, sir? What do you have to say? Let us know.
I just clarify, my lord, that it didn't have the approval of the competent authority.
Where is the approval?
My lord. The specific amendment. In fact, that was a pleading, my lord, which they made in the writ petition, and that was answered in paragraph 14, page 8 of my stay vacation application. I don't know whether they have annexed it.
Application,
Writ appeal
Yes, my
have
lord,
you
it's
annexed?
at page 105, my lord.
yes, let's see. Let's see.
105.
Where is writ appeal? Huh? Okay, so can you give me the copy of the writ appeal, because extra copy, we don't have the copy. So, my lord, I'm sorry, because since, my lord, we don't have the copy of the writ appeal.
The application was filed by your good self. Your record must be containing your
My
application.
lord, my application is there.
So it is there. He has pointed out which para.
Paragraph 14, 1-4. Para 1-4, page 8, internal
Yes.
of my stay vacation application.
Transfer was recommended by a committee
Please,
and finally approved by the chairman, managing director.
yes,
So that argument doesn't remain.
yes. my lord.
It's not controverted.
And then, my lord, apart from that,
Hmm.
in course of argument, my lord, I refer to certain paragraph of the guidelines itself, showing that CMD has exclusive powers also. In addition to that,
Where are the guidelines?
the transfer guidelines, my lord, the relevant paragraphs are para 3.12 of the transfer guideline, 3.12 Roman 4.
Page
The transfer policy that starts at page 93.
93.
3.12.
Yes.
Roman
3.12
4.
is at page 97, madam.
3.12 Roman 4. In situations involving administrative, whether my lord has, yes.
Yes.
In situations involving administrative exigencies, where consultation with concerned functional director is not possible, CMD may order such transfer in the interest of work. In addition, my lord, 3.15 also. The management, however, reserves the right to make transfer on administrative ground. So, my lord, the power is always vested in the management.
That he doesn't, initially though he disputed.
My lord, I still dispute that, my lord.
Okay.
In fact, my lord. at
Is
that
there
point of
any
time-
controversy of the amendments made in their application?
Yes, my lord.
That it has the approval of the
Yes,
CMD?
I have filed my affidavit controverting that, my lord.
All right, read please.
My lord,
Read your affidavit.
yes. my lord. In reply to para 14,
Page,
it's at page 128, para 12 of my affidavit, my lord. Lord, that I deny the statements made in paragraph 14 of the interlocutory application filed by the applicants and respectfully state that the present transfer order has not been issued citing organizational requirement and not on administrative grounds. If there was any actual administrative ground behind the impugned transfer order, the applicant ought to have brought the same to light. I further beg to state that the applicants have admitted that the transfer order was not recommended by the Committee of Director Personnel and Director Project, and this alone makes the impugned transfer order illegal.
Hmm.
In the impugned transfer order dated 10/3/2023, the reason for passing the said order was reflected as organizational requirement and not administrative ground. Hence, it is not open for the applicants to say that the same was passed on administrative grounds. While reiterating and reaffirming the statements made in paragraph 11 of my writ petition, I further respectfully state that by way of issuing part 2 office order number so and so dated 23/3/2023, Sri Rajendra Prasad Goel, Director Finance, was entrusted with the additional charge of Director Personnel retrospectively with effect from 3/3/2023. The same would make it absolutely clear that the post was lying absolutely vacant from 3/3/2023 to 23/3/2023. Furthermore, by another order, that is part office order so and so dated 27/3/2023,
Yes.
the HR division was asked to report to Sri Rajendra Prasad Goel. Thus, it becomes clear that the applicant corporation in its true sense got a part-time director personnel on 27/3/2023 only. I further respectfully state that another order being order dated so and so dated 7/4/2023 was issued by the applicant corporation entrusting Sri Rajiv Kumar Visnoy, CMD so and so additional charge of chairman and managing director, CMD for short, of the applicant corporation with effect from 1/3/2023, meaning thereby that the post was lying absolutely vacant from 1/3/2023 to 7/4/2023.
Yes.
Therefore, as claimed by the applicants, the impugned transfer order affecting my transfer could not have been finally approved by the CMD, and the same is an outright false statement made by the applicants.
All right.
To
Okay.
this period, I just clarify, post never remains vacant. It can't be the case CMD post is vacant. Somebody is
someone
always
has
in
to be
charge.
charged.
Yes, it
Someone
is
has to-
simple. And these are guidelines and we have, it's recommended by committee. CMD has
All
approved
right.
it.
Now we'll observe that the next transfer should be strictly as per the transfer guidelines to a hard posting.
Very good.
This gentleman deserves nothing else. His 10 years are being completed, so he should be moved to a proper place which he deserves.
There are few officers, my lord, they are by
They are,
nature, they are litigate.
that's true, that's true. We'll make that observation.
Yes, my lord.
All right.
I have instructions for that one.
To say he is ready to go to hard posting.
Yes, my lord.
That's
So
good.
next time you'll send me
Excellent.
Tawa. It's a nice
Excellent.
place.
There may be even better places.
Better place.
Yes. All right. All right, rejected. All right, we call out that criminal matter. Yes.
Item numbers 59 to 71, ordered matters.
Is the check. Or not. Yes.
Please, your lordship.
Hmm.
I hope this time, today it won't be a TikTok presentation.
Let's see. Hope so.
Yes. Your lordship, just to rewind back a little bit,
Mhm.
my lord, there was an FIR was registered on 1st of April 2009. In the FIR, it has been alleged that the
Where is that list of dates he handed over yesterday? Sir? Give us- I think it's, yes, all right. FIR was registered, cash was recovered,
cash was
money
recovered,
of, the arms were recovered,
arms of
certain documents were recovered.
certain documents.
Yes.
Those documents contain two parts. One was the empty blank letterhead of inscribed DSDJ and one letter addressed by Mohit Hujai for giving a work to a particular contractor.
Right.
And that effect, seizure was given effect, my lord, on 1/4/2009. On the basis of that FIR, the central government, the MHA, thought that it has got a larger ramifications because they in the FIR they have suspected that those two persons to be DSDJ cadres. So accordingly, on 1/6/2009, the NIA came up in the investigation, my lord.
Yes.
After the NIA came on investigation, my lord, I was apprehended with my other two co-accused from Bangalore, my lord, on 3rd June. Now, NIA re-registered the FIR, carried out the investigation, my lord. And finally, on 17/11/2009, the NIA filed the charge sheet. Now, my lord, the charge sheet was filed against 14 accused persons under section 120B, 121, 121A of the IPC, read with section 25, 1BA of the Arms Act, and section 16, 17, 18, and 20 of Unlawful Activities Prevention Act. The learned trial court, special judge, my lord, framed the charges on 4/8/2012. Now, your lordship, yesterday, though I have taken it, or I have requested your lordship to look into those charge headings. My lord, I will request your lordship can kindly look it once more. 4/8/2012.
Yes.
That will be, your lordship will find in volume 1 of the paper book, page 4. Since 121,
Yes.
my lord is there, page 4.
Yes.
The learned trial court charges 9 persons individually, my lord.
Yes.
There was a common charge for every one of those 9 persons. First
What
was
the FIR, the charge sheet was against 14 persons.
14 persons.
What happened to the remaining 5?
But remaining 5 subsequent charges on other dates, my lord.
All right. Okay.
That your lordship will find in page 7.
Why there was a spillover? Or
My
there
lord,
was a,
they filed because as far as the records reveal, my lord, RS Khan moved an application on a particular day. So the charge order heading was framed on a subsequent day.
the language of the charge is same.
Language of the charge is same.
All right.
Your lordship will kindly see the first charge under 120B of IPC. There are 3 ingredients in there in the charge head. That you are forming a terrorist gang, DSDJ or Black Widow in 2004. Means those 9 persons we formed a terrorist gang or Black Widow in 2004. And particularly during the period of January to March 2009.
Yes.
Here I'm referring as myself, my lord, that I entered into agreement with RS Khan, Jayanta Kumar Ghosh, Karuna Saikia, Devasis Bhattacharjee, and Sandeep Ghosh to do illegal act or an act which is not illegal by illegal means. What were those acts, my lord? That is to raise fund for the terrorist gang by cheapening of government fund. First. Second was the converting of Indian currency to US dollar. Third, to procure arms and ammunition to wage war, cause death of innocent persons, terrorize the people and extort money, kidnap for ransom, disrupted works of gauge conversion and construction of east-west corridor of 4-lane national highway, etc., and thereby committed an offense punishable under 120B IPC and within my cognition. So in the 120B conspiracy, my lord, that I entered into entered in an agreement with 4 accused, co-accused. I siphoned the money. I extorted money. I terrorized people. I kill innocent persons. and hampered the road construction project and brought railway connectivity of that particular area. And period was up from January to March 2009. That is the conspiracy charging. Now, my lord, 121A and 121 IPC, I'm not referring here because that has
Is
been
it acquittal?
acquitted.
Yes.
Now, kindly come to the fourth head, charge head.
Yes.
That I being a member of Dima Halim Dauga, in short DSDJ, a terrorist gang did terrorist act by killing 10 innocent truck drivers in May 2008. That is the first terrorist act. 7 CRPF personnel, 7 Assam Police personnel in 2008. Disrupted the development work such as gauge conversion, construction of east-west corridor, which are essential services to the life of the citizen, kidnap and abduct person for ransom. Third was the, my lord, that I overweight elected chief executive member Dipolal Hojai of NC Hills District Council in January 2009, etc. And thereby committed an offense punishable under section 16 of the UAP Act.
Yes.
So, my lord, in as far as the Terrorist Act, which the Learned Trial Court framed the charge, was that killing of police officials, security personnel in the month of May 2008, disrupted the development works, and third, under duress, I compelled that chief executive member of the Karbi Anglong or NC Hills Autonomous Council to resign. These are the 3 terrorist acts under which section 16 charge was being framed.
Yes.
Now, fifthly, my lord, the charge here was under section 17, my lord. Here the ingredients of 17 was there, my lord. Raising and collecting funds or attempt to collect funds by extortion, kidnapping, siphoning and deflection of government funds through Mohit Hojai and others. And in committing such activities, we kidnapped R.S. Gandhi and realized 4.5 crore. That kidnapping part of Mr. R.S. Gandhi, and we extorted 4.5 crore. And making false challans and bills from the government, and we extorted money.
Defalcation.
Defalcation, my lord.
All right.
That is section 17, my lord.
Mm.
Now, 18, we have not been convicted, my lord. Now, as far as 20 was that, since charge under 20 was framed because of the charges mentioned in section 16, my lord. And 25(1)(d), my lord, the trial court found in the contents of the charge sheet that we imported or we brought in arms and ammunition in contravention of section 11 of the Arms Act, and accordingly 25(1)(d) was being framed. Now, these are the broad charges, my lord, charge head, which the prosecution was supposed to prove, and the Learned Trial Court should find the evidence and convict me. Now, before I go into the evidences, your lordship, if we kindly come to the charge sheet, that is at volume 9, paper book, volume 9.
Yes.
The lordship will kindly come to page 2216. Your lordship will kindly see there is a heading at page 2217, numbered as 17, facts disclosed during investigation, my lord. 17.1 is that the fact what has been come up from 17.1 is that Joel Garlosa is the chairman of the DSD, and he adopted the name Black Widows and carried out violence in Kachar, NC Hills, Nagaon district of Assam, and Dimasa dominated areas of Dhansli and Karbi Anglong.
Yes.
Second, your lordship will kindly see 17.3, second allegation was that I had a link with other terrorist organization, that is NSC and IM and NDFB. Third is that 17.4, my lord, the main activity which has been attributed to me, my organization, was that we siphoned the government funds through extortion with the help of the elected members of the council and government servants under the subversive for carrying on the subversive activities. And in that process, the infrastructure project in those areas suffered, my lord. And in 17.4 of the charge sheet, they brought in that 3 major ambushes within the meaning of 15 of Unlawful Activities Act.
Yes.
My lord, if I read that particular para at page 2219,
Yes.
1, 2, 3, 4, 5, 6 line. Thus, it is evident that the DSDJ has been indulging in terrorist acts within the meaning of section 15 of the UAP Act 1967,
Yes.
because referring to those killings. Now, on 17.7, my lord, they are saying that under the support of DSDJ, the alliance which was there in the Autonomous Council between the BJP and ASDC party, Depolal Hujai, under the blessing of the DSDJ, he was installed in the government, but he failed to deliver the needs of DSDJ. Now, on 17.11, my lord, the act attributed is that the arrest of Projender Hojai and Babul Kamprai on 1st of April 2009. The other allegation is that, assertion is that I was arrested on Bangalore and was living in under a false name by concealing my identity. And the last is that communication with other militant organizations through email of one of my co-accused, Arsing Dowari sir. And I visited foreign countries, Vietnam, Thailand, Nepal, for in furtherance of strengthening my organization by collecting arms and ammunition, my lord, foreign visit. And the last is that the channeling of fund of DSDJ through Hawala at Kolkata. On this basis, my lord, the learned trial court framed the charges, which I have already taken your my lord's attention. Now, if we come to the impugned judgment, that is volume 8 in the paper book, my lord. Yes. My lord is there. 11 page will be 1995.
State the para of the judgment you want to refer.
My lord, it comes to 165. It starts from 165.
Yes.
Here what happened, my lord, in the impugned judgment, the learned trial court has individually discussed that with all the evidences, all the accused. And in my case, my lord, out of 150 witnesses which the prosecution examined in the trial, only 24 witnesses were taken in against me. On the basis of those 24 witnesses and the connecting exhibits done by them, the learned trial court came to a conclusion for leveling that, attributing those circumstances which was being used for my conviction.
Yes.
That your lordship will kindly come at page 2003. Para, it will be 189.
Yes.
The role played by these accused can be recapitulated as under. Number 1, DSDJ, a militant organization led by Jewel Garlosa. Number 2, the arms and ammunition required for operation of the organization were purchased locally, also used to get from Bangladesh. He is the chairman, and Dilip Nunisia was the vice chairman, and Pranab Nunisia was the CNC. On 1/1/2003, the organization declared ceasefire and the 300 cadres were shifted to the designated camp. Number 5,
In October 2003, he formed another militant organization in the name of DSDJ. Sixth, Purnendu Langthasa, who was the chief executive member till 2006, was killed by extremists in 2006 during election campaign. An accusing finger is pointed out to DSDJ and Morung Dimasa, who belongs to DSDJ. 7, many efficient government officials were reluctant to be posted at NC Hills because of extremists for which developmental work suffered. There was 2 groups of extremists, DSD and other was DSDJ, and there was killing and kidnapping. 8, there was spurt of violence because of DSDJ, due to which train service flying from Lamding to Badapur was stopped, and food grain going to Barak Valley, Mizoram, Tripura, and Manipur was stopped. DSDJ group had resorted to firing on moving train. 9, because of counter-insurgency operations, laying down of arms by DSDJ cadres in March-April 2010 took place, but there was apprehension that all the arms and ammunition of DSDJ were not handed over at the time of laying down of arms. 10th, on 8/7/2010, at Disa Kisan area, which the search was conducted, and several gunny bags containing sophisticated weapons, including AK-47, M16 pistol, lethal guns, as well as M21 rifles, and in connection, Haflong PS case number 54 of 2010 was registered. 11, he was apprehended in a gym, and Partho Barisha was apprehended in a flat 102 first floor Pankaj Residency along with Samir Ahmed, and they were brought to Guwahati on 5/6/2009. And among other things, one driving license number KA 2509/09-10 in the name of Joel Garlosa as Debojit Singha, having his photograph was found and seized. 12, emails sent by him to NDFB organization were recovered from one email ID, dimahasau@yahoo.com with password Tomahawk belonging to accused A. Warisa on the disclosure made by accused Archindo Warisa. 13, 3 blank letterheads of DSDJ have been recovered from the possession of Pojendra Hujai on 1st of April 9, while he was carrying 1 crore to Shillong. So total 13 attributes have come against me on the basis of the evidences which the learned trial court dealt. Now, your lordship, if I pause here for a moment, and if we try to look into the charges which has been framed against me, not a single ingredient of those charges has come up in the factors which the learned trial court found against me and later on convicted. Now, my lords, before we deal with much more, I would like to refer to the provisions of Unlawful Activities Prevention Act. Yes. My lord, has the old edition, my lord? Yes. My lord, if we start from the definition part, section 2K. My lord, 2K. It has been said that Terrorist Act has the meaning assigned to it in section 15, and the expression terrorism and terrorists shall be construed accordingly. So Terrorist Act has been defined in section 15 of the UAP Act. Now, if we come to section 15, I'm reading it, my lord. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people in India or in any foreign country. A, by using bombs, dynamites, or other explosive substances or inflammable substances or firearms or other lethal weapons or poisonous or noxious gases or other chemicals, or by any other substances, whether biological, radioactive, nuclear, or otherwise, of a hazardous nature, or by any other means of whatever nature, to cause or likely to cause, number 1, death of or injuries to any person or persons, or number 2, loss of or damage to or destruction of property, or Third, disruption of any supplies or services essential to the life of the community in India or in any foreign country, or damage or destruction of any property in India or in a foreign country used or intended to be used for the defense of India or in connection with any other purposes of the government of India and any state government or any of their agencies. B, overreach by means of criminal force or the show of criminal force or attempts to do so or cause death of any public functionary or attempts to cause death of any public functionary, or detains, kidnaps or abducts any person and threatens to kill or injure such persons or does any other act in order to compel the government of India, any state government or the government of any foreign country or any other person to do or abstain from doing any act, commits a terrorist act. My lords, will appreciate that Section 15 Terrorist Act starts with a German word called intent. There has the mental element, that is mens rea, has to be there. Actus reus is not of least consequences. First, the mens rea has to be there. Now, if I take the entire allegations against me is true for the sake of argument, first thing which I can find is that at best, what NIA can say, to be a terrorist act, in my case, is that the resignation of Depolal Khojat.
Yes.
At best. Though what has happened in the trial, that's a different thing. In the charges, we can say that portion can. But the moment your lordship takes that to the terrorist act, now the question will come that whether there was any intent on the part of these individuals who have been charged to drag the dragnet of Section 50 of Terrorist Act. How, my lord? The lordship will kindly see that there was a similar provision, parameter provision in TADA Act, and your lordship will appreciate that Nalini judgment. I will take your lordship to that Nalini judgment, 1999. My lord, I have given 1999, 5 as to 250. My lord.
Yes.
Para 650, your lordship. The provisions of subsection 2, 3 and 4 of section 3 of TADA Act would be attractive only when a person accused of the offences under the said provisions has committed a terrorist act within the meaning of section 3.1 of TADA.
Yes.
Section 3.1 read as under, whoever with intent to overlay the government as by law established or to strike terror in the people of any section of the people or to alienate any section of the people or to adversely affect the harmony among different sections of the people does any act or thing by using bombs, dynamite or other explosive substances or inflammable. That is the content of the section, my lord. So what I am trying to draw is that the actus reus, that the action should be led by mens rea, that is the mental element, intention. And this, what your lordship, a perusal of the provision extract above shows that it embodies the principle expressed in the maxim actus non facit ream nisi mensit rea. Both mens rea and a criminal act are the ingredients of the definition of terrorist act. Subsequently, para 651, my lord, Mr. Altaf Ahmed, learned additional Solicitor General, has developed an ingenious argument that as the acts which are committed by the accused persons have the potentiality to override the government and to strike terror in the people or any section of the people, the requirement mens rea has to be inferred. A perusal of the charges disclosed that the intention to override the government is not mentioned therein. However, Mr. Altaf Ahmed, relying upon the provisions of section 211, 212, 215, 464 and 465 of the CRPC, has submitted that omission to mention the ingredients of the charge did not result in misleading the accused persons and the words and through the words to overweigh the government. It were not mentioned in the charge is not bad in law. He relied upon the judgments, my lord, in support of his contention. In my view, the question here does not relate to the defect in the charge, but to the content of the charge. And without the said German words in the charge, it cannot be said that the charge includes the intention to override the government. The charge framed is confined only to those acts which are referred to therein. This is also the view expressed by my learned brothers. So, my lord, what was that? You in the panel provisions, we have to be a strict interpretation is there. And furthermore, my lord, when you're framing a charge, we cannot infer in the contents of the charge, that we cannot draw an inference. What is there in the charge, that the entire trial will be restricted to that.
Yes.
It cannot go beyond that. So, my lord, in the present case, if we see the charge again, your lordship, at page 4,
Yes.
that as far as section 16 is concerned, my lord, may I read it, my lord? That you being a member of DSD, in short DSDJ, a terrorist gang, did terrorist act by killing 10 innocent truck drivers. So it talks about the actions, consequences, but there is no question, there is nothing on to show that it has been, this charge has been framed within the parameters or within the compass of section 15.
Yes. You have to read it with first charge. You have to read it with first charge. It can't be in isolation.
My lord,
The entire charge has to be read as such.
my lord, that you, after forming terrorist gang, DSDJ or Black Widow in 2004, and particularly during the period of January to March 2009, entered into agreement with R.S. Khan, Jayanta Kumar Ghosh, Karuna Saikia, Devasis Bhattacharjee, and Sandeep Ghosh to do illegal act or an act which is not illegal, but by illegal means, that is to raise funds for the terrorist gang by siphoning government fund, convert Indian currency to US dollar, to procure arms and ammunition to wage war, cause death of innocent persons, terrorize the people and extort money, kidnap for ransom, disrupted works of gauge conversion and construction of east-west corridor of 4-lane national highway, etc., and thereby committed an offense punishable under section 120B IPC and within my conclusion. So, first charge is of conspiracy, my lord. Conspiracy itself does not create a separate offense. It will come up.
Yes.
So, my lord, what I am trying to impress on my lords is that
mens rea is lacking.
Mens
That
rea
is
is
what your
lacking,
argument.
and the moment it is not a question of defect in framing of charges or it's a curable thing. It's the question is that when you put a man for a trial, you must make him clear that you under what offenses
He
you are
must
putting
be informed of the charges
charges.
pertinently. Yes.
So, and that is what Nalini's case said, my lord, as far as section 3. Even, my lord, our own high courts, one high court judgment was there, my lord.
We will continue at 2.
My lord. Obliged.
We uphold the findings. We uphold the findings of recorded by the learned single judge in the impugned judgment and order dated 10/2/2023 in WPC 8318 of 2019. The writ appeal is devoid of merit and the same is accordingly dismissed. No order as to costs.
Matter number 2.
Yes, yes. You mean? In view of our above discussions, we find no merit in the appeal to interfere with the views and conclusions arrived at by the learned single judge by D. Judgment and order dated 6/8/2018. Accordingly, this appeal being devoid of merit, the same is dismissed. No order is to cost. Obliged. So
my lord. So pre-lunch, my lord, what I was trying to impress upon you, my lords, was that
Yes.
I drew the kind attention of this honorable court to first was the materials on the basis of which the charge sheet was being filed by the NIA, and the basis of which the basis on which the learned trial court framed charges against me and other co-accused, my lord. And I took around this honorable court from the evidences which the learned trial court looked into, that is only 24 sets of witnesses out of 150, and came to the attributes level against me.
Yes.
13 factors were level against me. And I drew this kind of attention of this court to the judgment passed by the Honorable Apex Court in Nalini's case, because with respect to Section 3 of the TADA Act, since Section 3 and Section 15 of the Unlawful Activities Act are in perimetria, my lord.
Yes.
And the German word is the intent. It is not the defect of the charges, my lord. It is to be there because it goes with the maxim. So now, if I lordship, we pause for a moment and we see the judgment again, the impugned judgment. What I can find out, my lord, I gave a reading, I reread it, I found that the learned trial court relied upon the evidence of 3 witnesses to come to say, though it is not reflected in the page 203, the 13 points which they have kindly, page para 189, my lord, para 189. If I read it again and again, I don't find any terrorist incident or a terrorist act of a particular place, date, time. But if what I find is that the issue, that is the attributes at 8, serial number 8, my lord, that there was a spirit of violence because of DSDJ, due to which train services flying from Lamding to Badarpur was stopped and food grain going.
Why not para 7?
My lord, that I will come, my lord. It is 146 other witness was there. PW24, the evidence of PW24, which the learned trial court recorded, my lord, from his evidence, the learned trial court attributed these 2 facts, 8 and 9.
Yes.
And 10. 8, 9, and 10. My lord,
PW24.
PW24. My lord, may kindly come to PW24. His evidence is volume 1, my lord. Page 81.
Yes. Yes.
I joined in March 2009 as additional SP headquarters at NC Hills. I continued up to December 2010. NC Hill is presently known as Dima Hasau. At NC Hill, I was responsible for maintenance of law and order and crime detection in the area. Immediately after my joining, there was spurt in violence because of DSDJ. There was Naga and
Spurt, not spurt.
yes, spurt. Pardon, my lord?
The pronunciation of SPURT is spurt in violence.
Spurt in violence. my lord.
Yes.
Sorry, my lord. Spurt in violence because of DSDJ. There was Naga and Dimasa ethnic clashes. DSDJ has stopped the train services flying from Lamding to Badarpur, thus virtually stopping the food grains not only to Barak Valley, but also to states like Mizoram, Tripura, and Manipur. DSDJ would resort to firing on the moving train from the hills on both sides of the more than 120-kilometer railway track. This was the situation when I joined. Because of CI operations, lots of additional forces were deployed. Things gradually improved. Finally, leading to the laying down of arms by DSDJ cadres in March, April 2010. But there was always a feeling and apprehension and some intelligence input as well that all arms and ammunition of DSDJ were not handed over at the time of the laying of the arms. On 8/7/2010, we received the specific information that a consignment of arms and ammunition were kept hidden in a jungle. After verifying this incident, that there was some authenticity in the input that we received, I, on the instruction of the SP Dimahasau, conducted a search at the Disa Kisan area. I was accompanied by OC Haflong, a large number of forces. Thereafter, on search, we could find several gunny bags, some behind rocks and some concealed with earth. And on opening the sacks, we found a large number of sophisticated weapons, which included AK-47, M16 pistols, lethal guns, as well as M21 rifles. We found that these were indeed highly sophisticated factory-made weapons. There was no question of witnesses, as there was no habitation in the area, and it was a dense jungle. But in presence of police witnesses, the arms were seized. Thereafter, I informed the SP about the recovery, and I was instructed to take all the weapons back to the headquarters. On returning back to Haflong, the officer in charge, Haflong PS, lost the FIR, and a case was registered as 54/10. The original copy of the FIR would be in the case record. Exhibit 57, photocopy of the format of FIR number 54, dated 9/7/10. This was under objection, my lord. Exhibit 57-1 is the signature of OC, Sangha Sarugari. Exhibit 58 is the photocopy of the FIR. That is also under objection, as he is not the maker of the document. Exhibit 58-1 is the signature of OC, Sangha Sarugari. Exhibit 59, photocopy of the seizure list containing 44 numbers of weapons and 41 assorted magazines and shells. Under objection, it is the photocopy, and he is not maker of the document. Exhibit 59-1 is the signature of OC, Swanka Sarugari. Exhibit 60 is the photocopy of the letter dated 16/7/2010, addressed to SP NIA, New Delhi, camp at Guwahati, annexing FIR and the seizure list. Exhibit 61 is the signature of OC, Swanka Sarugari. Exhibit 61 is the photocopy of the letter dated 3/9/2010, addressed to the SP NIA, New Delhi, camp at Guwahati, informing regarding the status of Umrangso PS case number 6/1 and Umrangso PS case number 18/2000. I have informed that both the cases were charge-sheeted against Pon Naiding and Thangbong Hansu, both DSD cadres. Your lordship will kindly appreciate that this particular investigation which they carried out on prosecution, a trial was carried out. It was not with a DSD. It was with, they alleged that it is a DSDJ. So DSDJ and DSD are two different entities, my lord. And in the second case, 18/2000, Onol Phanglo, Mongdesa Langtasa, and absconding accused Peter Langtasa, Biren Singh Langtasa, Thanjana Hafilia, Asai Ram Nunsha, and Ajit Thausen, all are DSD cadres. Exhibit 61 is my signature, but the said letter I have enclosed the copy of the FIR under objection as it is photocopied. Now, my lord, if we see his evidence, I'm not going into cross at this stage. If we see his examination in chief, that is the prosecution's version, there is just a whisper that it was they suspected it is the arms of DSDJ, my lord. There was just, but when they filed a charge sheet, when they carried out the investigation, it was with a DSD. Now, if we see the exhibits, my lord, kindly come to the exhibits. Only one. My lord, paper book, volume 1 of exhibited documents. That are 125 pages.
Yes, page.
Page 125. My lord is there.
Yes.
My lord, this is the FIR format.
Mm.
The FIR was district was of Dima Hasa Haplong, year 2010.
Yes.
FIR number 54 registered on 9/7/2010. In the meantime, my lord, we were already behind the bars. I was apprehended on 2009. Now, my lord, under section 25(1)(a) of the Arms Act. Occurrence day is 8/7/2010. Information received was of 9/7/2010 at 1 AM. GD is 249. Place of occurrence, serial number 5, at about 28 kilometer, Dikasin area on north south east, Dikasin and Mahur Road. I will kindly see the complainant, that is Shankar Sargari, SI of police. Details of known, suspected, unknown, accused with full particulars. Serial number 7.
Unknown miscreant.
Unknown miscreant.
You read that.
I will kindly come to page 127. That is the.
Is there a charge sheet of this case?
No, my lord.
Charge sheet of this case?
No.
It's not exhibited.
It has not exhibited. Later on, we as a defense witness, we examine, because in this particular case, FR was being given.
For want of knowledge of accused. It was not found.
Accused not found. There is no material evidences.
Presumed. Right.
So FR was being given because at that time, my lord, Dima Hasa they did not have a separate judiciary. So it was the district magistrate presided as district judge. And the investigation was carried out for a long period of time. They could not connect with any evidences. So that was, it was being closed. The police filed the FIR. We have examined the concerned officer as a defense witness, my lord.
Okay.
Particularly one more aspect which I want to draw, your lordship. Kindly, if your lordship kindly peruse the NIA Act, section 8.
Yes.
Section 8. Power to investigate connected offences. While investigating any schedule offence, the agency may also investigate any other offence which the accused is alleged to have committed if the offence is connected with the schedule offence. Means, your lordship, when as far as PW 24 is concerned, he comes and he deposes in the court that one or acting on a particular information, they gave a raid. They recovered arms and ammunition suspected to be of DSD, but in the FIR it is some unknown miscreants. The fate it was FIR was given in that matter. Be that so, this information was forwarded to NIA. The NIA, it was a part of their record. Who stopped them from carrying out investigation under Section 8? Without carrying out investigation under Section 8 of the investigating agency, the learned trial court. How can the learned trial court, with all humility in my command, can draw an inference, remote inference also, to convict me of Section 16 on the basis of this particular fact? That is one. Secondly, my lord, I will show this honorable court that on the basis of same set of evidence of PW 24, the learned trial court in the impugned judgment has acquitted us of offences under Section 121A. The reason what was cited was that, my lord, that the evidence of PW 24 does not inspire confidence because there is no incident of a particular incident where
waging war
or any activities. So on the basis of same set of evidence, can one be acquitted and one be convicted on the same set of evidence?
Yes.
So, my lord, this is PW 24. My lord, the letter which they referred in the in the examination in chief, my lord. The lordship will find at page 132.
What letter?
The case details which the PW 24 SP of Dima Hasao sent to the my lord, the Superintendent of Police NI.
But they were again charge sheeted against two different persons. Funen, Nangin.
Yes, my
and-
lord. But it is nowhere, but this learned trial court relied on these evidences.
Yes.
That is why I was trying to, my lord, to take on to those statements. If I'm clear, then I can go to other purposes.
Carry on, carry on. The officer himself says charge sheet was against two other persons.
Two other persons.
Yes.
And two other persons, both were of DSD cadres. The case is not with the DSDJ or if, for example, my lord, if you take it for on the, that everything is gospel true.
Who is the best witness as per you who proves the fact that you are the person in charge of DSDJ? 129?
My lord, 129.
Read the
My
statement of
lord,
129, criticize him.
My lord. 129 to the PW 110. My lord, it is at page volume 3, paper book, page number 640. Dilip Nunisha, my lord.
Yes. 640.
Page 640.
Read.
Today I have appeared before the court.
He is the only person you need to address the court about.
My lord.
Yes.
Today I have appeared before the court on receipt of the summons from the court. In the year 1990, I was student leader. In the year 1995, I have joined as a member of DSD group.
Yes.
The group was led by the then President Joel Garlosa. DSD's objective was to create a separate state of Dimasa people within the territory of India. I remained with the organization till the ceasefire was signed with the government of India and Assam in the year 2003, with effective from 1st of January 2003. Our organization DSD worked for general upliftment of the people of the locality and their educational and other rights, and also for their social upliftment. I do not correctly remember that I was interrogated by NIA officials in connection with this case, and I also do not correctly remember if my statement was recorded in connection with this case. He stopped there. The prosecution declares him a hostile witness. On the basis of that, confrontation, what the prosecution tried to reduce, on that particular thing, the learned trial court has recorded it. Because this was what they have done with this particular portion, my lord, which they have denied, that was been confirmed from PW 150. And my lord, your lordship will appreciate that on the very first day, your lordship was of the view that that can be done because there is a judgment of catena of judgments. Even I will cite one judgment, my lord, Vijendra's case, where the Honorable Apex Court has held that if a particular witness does not say a particular fact, then the practice of the trial courts getting confirmed from the IO reciting the entire thing is totally not possible, my lord. It's not allowed. The lordship will kindly come to page 641, second last para. It is correct that when I became the member, we thought for our right, and during that time I used to remain in different jungles within our district. We got our training in camps where we were provided by our leaders dummy weapons made of wood. At that time of ceasefire in the year 2003, I was the vice president of DSD and I participated in the ceasefire ceremony. It is correct that there was a communal clash between Mar people and Dimasa people. It is correct that a number of Dimasa people lost their life during that clash. It is correct that Joel Garlosa separated himself from our organization. It is known to everyone that after the clash between the Mar and Dimasa people, Joel Garlosa formed a group called Black Widow. In the year 2004, there was a joint meeting between Government of India, Government of Assam and our organization. In that meeting, I was present and I remembered that from the government side, Mr. B.K. Gohain and Rajiv Agrawala was also present. I remember that Joel Garlosa was not present in that meeting. My lord, this particular thing, my lord, this particular deposition, which he have deposed in cross-examination by the prosecution, at best, we can say that he says that I was the person who formed Black Widow. But no covert or overt act can be attributed to me. And if a lordship, that is, these are the facts what he have deposed. It's a common fact. That everybody were aware that there was a ethnic clash in Dima Hasao at that point of time between the Mar and the Dimasa people. Now, what is happening in Imphal, my lord, Manipur? Manipur is burning because of certain issues. So it is a common thing happening in this part of the country, my lord, because of a lot of other ethnic issues are there. But that issue, if a particular person goes and forms that I am Black Widow or ABC, by mere forming of that, that cannot be attributed as a terrorist organization, terrorist gang, without any evidence or without any overt or covert act, suggesting that a particular act was committed, which attracts the definition of terrorist act under section 50. Besides this, my lord,
what was he confronted with? Not exhibited, but hopefully those put that statement being in the court. It's something. And how is it proved? Not exhibited, but gave a previous statement. Examination can be by public prosecutor after declaring it. Can be in reference to some previous statement. It can be otherwise also. But then that has to be the portion that there was such a statement reported. Where is the statement? This much only they have brought this. Statement. Where is the statement? Statement is not there. We don't know. Statement made. Was the content of the statement? We will not read the 161 statement unless a particular part is confronted or confronted. That is. You conducted the trial.
yes, that's conducted the trial.
Please come this side. You have cross-examined the witness, right? After declaring him hostile. Declared him hostile and cross-examined him. Hostile in reference to what?
He did not
He did not.
support the earlier evidence that was made under
Which earlier evidence, sir?
made under 161.
Let us see his statement. Which earlier evidence are you referring to? Is it exhibited? What is this? What is the procedure of confronting a witness with his previous statement? Read.
If 161 to
Mr. Bogoin, give him 640.
161
640 ye lijiye. Take this. Read. Please, which previous statement? You have to state from this very evidence that this was the previous statement from which he resided. Read which previous statement?
It is the first, it is not a fact that I stated before NIA. Yes, under. Early in the year 1990, that DNS
Oh, sir, just a minute. We are asking you which previous statement, on what date was it recorded? Who recorded it?
that we have to go to 161 statement, Malad.
Can it be?
Yeah.
Can it be read now? Without even confronting the witness? What does cross-examination from your own witness mean? You have to confront him with your previous version. Where is the previous version?
That was recorded on 17/6/09.
Who knows? You may be knowing it. We are not referring to 161 statement. Now that the witness has been examined, whatever you want to point out will have to be from his sworn testimony, right? What is the way of confronting a witness with his previous version? You put that part to him, which as per you, he has resiled from the earlier version.
Yeah.
Where is that part from the statement?
my lord.
Did you tell the witness that this is your previous statement, exhibit so and so? And that you are telling a lie because earlier you stated in this manner?
Madam.
Where is that exhibiting, sir?
That was said, madam. I don't know, everything has been recorded, no, madam.
Where is the previous statement exhibited?
The whole statement, no.
Not even the whole, the parts of statement which you rely upon.
Madam, that is in court, madam, your lordship will say, early in the year, that is quoted. Quoted. That was what
Quoted
Yes.
from where, sir?
160,
From your without the 161 statement being put,
161.
without the 161 statement being put.
It was confronted to him that you have made a statement before the police.
Which
This is
statement, sir, again?
Madam, may I-
Back to the square one. Without exhibiting that statement in this evidence, can the IO come and exhibit it?
the whole statement was not exhibited.
Whole, not even the whole, the part. Which
Maybe-
part?
Maybe-
Sir, which part of the statement did you confront the witness with? Show us from this document.
Which part for it?
Portion A to B, B to C, C to D. Where are those parts? You did not even mark an exhibit on the statement when you cross-examined him.
Madam. Hey, kun hit later, person here. Earlier in the year, first part. Okay. Yeah, yeah. It is there, my lord. It is there in the 161 statement, my lord.
Oh.
Ali, the first.
We are not even allowing you to touch the 161 statement unless you can show that the witness was confronted with that statement.
This statement.
And for that purpose, you have to mark an exhibit. You have to mark those particular portions with which you are desirous of confronting the witness. That is the way of doing it. Read Evidence Act, please. Evidence Act. In this trial, both the prosecution and the court, they have rewritten the Evidence Act. We feel.
One. One particular.
Read 155,
Yeah.
subclause 3.
By proof of former statement inconsistent with any part of its
Yes.
evidence which is liable to be contradicted.
So which part of the previous statement are you referring to?
My lord, this statement was shown to him. And that is
Oh,
what- my lord,
wonderful.
that is-
We should have a video recording called.
That is what it was done. Whatever. It was shown to him that we agree to that you have resigned.
Very good. It was shown to him and now we should ask the trial court, the presiding officer to come here and tell us that it was shown to the witness.
Here in the trial court, they do it in this way.
Do you subscribe to that view?
My lord,
You are the prosecutor. You should have said, sir, as per Evidence Act, I am required to mark an exhibit
exhibit it.
and I will have to mark the particular portions with which I desire to cross-examine the witness. The section is very clear, you read.
My lord, I-
That particular portion, because the entire statement cannot be exhibited. Unless he says, if he says that, yeah, I did not give a statement, then you can exhibit the entire statement also.
entire statement.
But without exhibiting, where is the confrontation?
Well.
Nothing, zero. So that previous statement, otherwise also, the IO is the one to come and say that this is the statement recorded by me, unless the witness was confronted with the statement. All right. Yes. Carry on, Mr.
Your lordship was right, fairly correct. This, if the witness would have said that I have not given any statement, which he did.
Yes.
After that, he was declared hostile.
Hmm.
The best way is that, my lord, the moment he should have been marked as A, B, or C and cross-examined.
So,
That is
Govind,
what
that
they
was-
should have seen.
That was not an argument advanced earlier.
Pardon, my
You are
lord.
just banking on the observations made by the court.
No, my
You
lord.
never raised that argument.
My lord, we have raised it. We filed an application also. I will show to this court, my
Okay,
lord.
very well.
Because these particular evidences, these witnesses,
Hmm.
who became hostile, the star witnesses all became hostile.
Hmm.
The prosecution said that you became hostile because you have been threatened or influenced by Joel Galosa, Mohit Huzai,
Hmm.
and this Niranjan Huzai.
Yes.
This was only a suggestion, my lord. I'm just putting a fact, my lord.
Yes, yes.
After that, what? The Mohit Huzai, Joel Galosa and Niranjan Huzai, since we are on peace talk, we have granted interim bail. Our bail has to be extended every 4 months. The trial was going on.
Hmm.
They are declaring every witness hostile and putting that because of Joel Galosa and Niranjan Huzai, you have been
Hmm.
threatened.
Hmm.
So hearing, not a single application was filed before this court for cancellation of our interim bail.
Forget about
My
that.
lord, second thing, my lord.
Hmm.
Second thing, I'm checking how the conduct fair investigation is there.
Hmm.
Second thing, my lord, we asked a pointed query to the chief investigating officer.
Yes.
Did any witness came and told you that he has been threatened by anyone on this facing trial?
Yes.
He said that no, I have not received and I have not filed any application also.
Yes.
So that's what I am showing, what I am trying to impress upon my lords is that the investigation has to be a fair one. From the day very one, it's not a fair.
All right. Carry on. Carry
My
on.
lord.
Yes.
So on this evidence, my lord, on this evidence, the landed trial court
Yes.
took the inference, drew the inference that these acts constitute a terrorist act under section 50.
Mr. Prosecutor, read 145 also. You can cross-examine the witness without showing the writing, but if you want to contradict the witness with reference to particular parts, you are referring to particular parts, you stated to the NIA X, Y, Z, then that part has to be shown, be called to those parts. Those parts which you are relying upon, unless those parts were shown to the witness, they cannot be treated to be a previous statement reduced in writing. And you have particularly quoted parts from the 161 statement without exhibiting it. And unless it is exhibited, we will presume that it was never shown to the witness. Yes.
Now, my lord,
No exhibiting of the statement. Statement practice. You would have made that. What happens? Same way. But sometimes it happens. Previous statement. That marked A to B, stated this point name B to the president from the exhibit B. That will be a prosecution. Yes, but yes, that unless you mark it, repeat the statement. We'll find n number of Supreme Court judges. 145. Yes. All right.
my lord, kindly come to page 643 of the evidence.
Yes, we are there.
The prosecution, after cross-examining him, puts a suggestion it is not a fact that because of my earlier affinity with DSD group, I have refrained from telling the truth. It is not a fact that because of influence put by Niranjan Hojai, Jewel Garlosa, Mohit Hojai, Pojendra Hojai, I have refrained from telling the truth. Now, in cross-examination, it is true that I was not prevented by Niranjan Hojai, Jewel Garlosa, Mohit Hojai, Pojendra Hojai from telling the truth in the court today. My knowledge about certain incident like killing of police personnel were gathered from media. And in regard to killing of other person from our group, I do not know who killed them.
Yes. Carry on.
My lord. No, what I wanted to show those my lords was that they, after declaring him as a hostile witness, they gave a suggestion that it was under the influence of the Mohit, Niranjan, and Jewel.
Yes.
So in the cross-examination, he accepts that whatever he has deposed, it was not under the influence of anyone, and whatever incident of killing, it is a hearsay we have got through media sources.
Yes.
And he is not aware of what has happened exactly.
Yes. Yes.
Now, on the basis of this evidence, my lord, if we come to page 2003
Of what?
of the impugned judgment,
Para?
para 189.
Yes.
The role attributed against me, which is on a trial court after relying on the evidence, serial number 6, 5, 6, and 7, my lord.
Yes.
He formed another militant organization name of DSDJ. Purnendo Langthasa, who was CM till 2000, was killed by extremists in 2006 during election campaign, and accused fingers pointed out to DSDJ, and Morung Dimasa, who belonged to DSDJ. Many efficient government officials were reluctant to be post NC Hills because of extremists for which development work suffered. There was two groups of extremists. There was killing and kidnapping, my lord. Because of
We will look at another the section of the I regularly take that in dust. Those are regular feature I would take on. Separate time. That was a regular feature. Yes.
now, your lordship, the other main striking point, which I will say if I use that word, if we see the charge order, if we recollect it, the framing of charge under section 16 was one constituent was that the resignation of Depolal Hojai under threat posed by DSDJ.
Yes.
Now, this gentleman was examined as PW 126. My lord can kindly see his evidence. The star witness declares becomes hostile. 625.
Yes.
Same paper book, my lord.
Yes.
My lord is there.
Yes. Yes.
In the year 1996, I contested autonomous council election from Wazao constituency, and I got elected from ASDC. And I became executive member of the council. I remained as such till 2001. In the year 2001, I did not contest the election, and I was busy in the work of my party. In the year 2007, I again contested election from the same constituency from the same party, and I got elected MSc of the council. After the aforesaid election, there was an alliance between the BJP and ASDC, and members of both the aforesaid parties who were elected as MSCs elected me as chief executive member of the council. And I took over as the CEM of the NC Hill Autonomous Council in the month of January 2008. Till 26 November 2008, I was the chief executive member. On 27 November 2008, I submitted my resignation from the post of chief executive member on health ground because myself and my wife were ill at that time. Exhibit 96 is my resignation letter to the governor of Assam, dated 27/11/2008. Exhibit 96-2 is my signature. The letter was forwarded to the governor by chairman, namely Mayanon Kemproy, through deputy commissioner. Exhibit 96-3 is the signature. After my resignation, Mohit Hojai was elected as CEM because during my resignation, the council was in session, and hence my successor was elected immediately. After resigning from the post of chief executive member, I along with my wife came to Guwahati for treatment. In the year 2013, I contested from the same constituency as an independent candidate. However, I lost the election. At present, the CEM of the Autonomous Council of Dima Hasao is Niranjan Huzai. In 2008, said Niranjan Huzai was in jungle. I know Joel Garlusa, who is now an elected MSc. He also contested the election in the year 2013 and was elected. In 2008, I do not know where Joel Garlusa was. He has not come to the politics during that time. During the time when I was CEM, these are the names of the party persons who were the members of the council. During the time I was the CEM, the law and order situation of the council was bad. In connection with this case, I was interrogated by NIA and I have given my statement. I do not remember the date on which I had given my statement. I remember the SP NIA Mukesh Singh has interrogated me. The witness declared hostile at the verbal pair of the prosecution. So he was declared hostile. And your lordship was correct. That particular portion was never marked or.
Where is the argument before the trial court that this witness was actually not confronted because the statement was not exhibited? You were just now shouting, we have given an application.
My lord, it is there. It is
What is the application? Read.
my lord.
Where is the application?
My lord.
Have you brought any judgment on 145 Evidence Act?
My lord, it is Tehsildar Singh's judgment is there.
What does it say?
My lord, Tehsildar Singh's judgment says that how to contradict a witness. If you want to contradict a witness, prosecution want to contradict a witness,
Yes.
that particular witness has to be drawn
Attention has to be
the
drawn
particular
to the
statement
particular
which is
part.
given earlier.
Yes.
And in that case, if he says that in his statement, he says that I have seen X stabbing B. But in the chief, if he denies, then it should be, the way should be, as per Tehsildar, that on so and so date, when you are investigating, you have deposed this particular, you saw A stabbing B. That has to be marked B. And then why are you telling lie?
Yes.
Then, and that after that, the person who recorded the statement.
He
that
will
is-
come and say that I recorded the
Yes, I
statement
recorded.
faithfully.
That is how.
Yes. That's right.
That is the procedure.
Yes.
And my lord, your lordship will be well aware of one, I would like to put it in criminal trials. When we put an argument in a criminal trial, we put our argument because of what is there in the evidence. What is there in evidence? And your lordship, it has been right from the long ages. It has been held by the apex court and even our own high courts that a trial judge should not be acting as a referee. He should take indecisive part. He has got ample right under the law evidence
165 of the evidence.
Yes.
Yes.
to put a query. And my lord, that particular application, my lord, I will definitely place it because it was in my part of my paper book for suspension of sentence.
Okay.
It is there, my lord. I will bring it.
Right.
When we filed the application, my lord, the application was filed when Mukesh Singh was investigated. Mukesh Singh was deposing in the court.
Examined. Okay.
Because the trial court allowed, the prosecution said to Mukesh Singh, what?
Exhibit so and so.
No exhibit, my lord. Mukesh Singh was examined like this, that you have recorded the statement of Dipolal Huzai? Yes. What did he say? On my record, so and so. That person was.
Where is Mukesh Singh? PW?
PW 150.
Let's come to 150 then.
Volume 4. Though I will go into Mukesh Singh evidence in detail, my lord.
Yes, we'll read. Yes, read.
Page 765, Mukesh Singh's.
Yes.
How his evidence, the evidence has been accorded. Page 765. During investigation, second paragraph, my lord.
Yes.
During investigation, I recorded the statement of Rong Singh Langthasa. For example, my lord, Rong Singh Langthasa, PW 20, under section 161. The aforesaid witnesses stated before me following. Quote, the entire portion which has been confronted, which has been declared
Recorded.
hostile, the entire thing. Second, again, come on page 766. 767, my lord. Mohinder San Nunisha. Same.
The statement is not exhibited.
not exhibited. What they did, what the prosecution did at that point of time was that the IO came that on this particular, did you recorded the statement of 161 statement of XYZ? Yes. And he has stated this. The entire thing has been cut, copy, paste. And on this set of evidences, the finding has been recorded. And on that very day, when my lord, PW 150 evidence was being recorded, there was a joint application. There was an application filed that the landed trial court should restrain from PW from prosecution from recording this evidence because he was relying on the 161 statements, everything.
Yes.
The landed trial court passed an order that we will look into this issue at the time of hearing. But I don't find that part has been done. My lord, I have got a copy of the application.
Yes.
I've got a single copy. Order is also there, my lord.
That particular part, when it's part is being marked, when the statement as the whole will be marked as a prospect, but from that perspective, the extracted, it will be safe. That's good. Yes. Okay.
My lord.
Give it to me back. Yes.
Your lordship will kindly, when I was making my submission yesterday also, though it was a very vague one, I would say, sorry, my apologies. Today in the morning, I told about that my stay of foreign parts. I went abroad, me, Niranjan and Valnan Chana. Your lordship, I will kindly come to evidence of PW 91. PW 91. Volume 2. Last space, I suppose, my lord. Second last space.
No, no,
No, evidence. Paper book apnar do.
Very clear.
Rajendra Singh Panwar, my lord.
It is Pawar.
Power, power, sorry.
Pawar.
Power. And is
Yes.
silent, sorry. On chief, my lord. Today I have appeared before the court on receipt of the summons from the court. During the year 2009-12, I was working as Assistant Director, International Police Cooperation Cell, CBI, New Delhi. On 28/2009, a reference was received from the IG, NIA, New Delhi, requesting for certain investigations through National Central Bureau, India, from NCB, Nepal, Thailand, Singapore, and Malaysia. Exhibit 307 in 6 pages is the said letter. Exhibit 3071 to 3074. On that day, I was holding additional charge of Assistant Director, NCB, Interpol, India. Hence, on receipt of the said reference from NIA in FIR number 1 of 2009, NI, I had made reference to the aforesaid countries for investigation on the points mentioned in the NCB letters. I assigned these references. The reference to NCB Thailand was regarding investigation for visit of Vanlal Chana to Bangkok in January-February 2008 and his stay at any hotel. A request was also made to verify the passport entry made in Hotel Nana Thai at Bangkok on 25th 26 December 2007 in the names of Bir Bahadur Chetri, Bir Bahadur Khara for Joel Garlosa, Shyam Thapa and Nirmal Rai for Niranjan Hudai. Exhibit 308 is the said reference. 308 is my signature. The reference to NCB Nepal was regarding verification of passport details of Joel Garlosa and Niranjan Huzai prepared in Nepal and details of stay of Joel Garlosa with Umesh Khara in 2007. Also verification regarding assistance provided by Umesh Khara to Joel Garlosa for obtaining a fake Nepali passport. Further subscriber details of telephone numbers so and so was also requested. Exhibit 309 is the said reference. Exhibit 3091 is my signature. In the reference made to NCB Malaysia, request was made to verify the passport entry made in the hotel Royal Bintang Hotel at Kuala Lumpur on 26 December 2007 in the names of Bir Bahadur Chetri, Bir Bahadur Khara for Joel Garlosa, Shyam Thapa and Nirmal Rai for Niranjan Hudai. Further verification of fake passports in the name of Bir Bahadur Chetri, Bir Bahadur Khara for Joel Garlosa, Shyam Thapa and Nirmal Rai for Niranjan Hudai was also requested. But exhibit 310 is the said reference, 3101 is my signature. In the reference made to NCB Singapore, request was made to verify the passport entries made in the hotel Balmuar and Supreme Hotel at Singapore on 19-20 January 2008 in the names of Bir Bahadur Chetri, Bir Bahadur Khara for Joel Garlosa, Shyam Thapa and Nirmal Rai for Niranjan Hudai. These persons had used their fake passports for the hotel booking and these passports could be used in their name. Subscriber details of telephone numbers so and so were also requested. Exhibit 311 is the said reference. Exhibit 3111 is my signature. My lord, this gentleman, the prosecution brought him to verify whether these three accused persons, Niranjan, Joel Garlosa and Vanlal Chana, whether they have gone to those foreign countries and stayed at those particular hotels in the fake name and passport and numbers. Now, they referred to those series of exhibits because of communication. But they did not exhibit the findings. What was the report?
Is that in the cross-examination?
Yeah, sound.
Right.
Worship, kindly come the cross.
Yes.
I had joined CBI as sub-inspector and retired from CBI as additional superintendent of police, but I was designated as assistant director CBI IPCC. During my service in CBI, I had the occasion of being investigating officer in about 100 cases. IPCC is not a part of NCB. The witness volunteers say that there is one unit named International Police Cooperation Unit headed by a DIG. IPCC and NCB come under the International Police Cooperation Unit. The exhibit marked as exhibit 3071 to 3074 are the enclosures to the reference made by NIA to the assistant director IPCC, who was me at that relevant point of time. On 9/9/2009, I have sent the request exhibit 308 to 311 to the respective NCBs seeking the information as sought by NIA by the reference marked here as exhibit 307. I did not receive any reply to the above reference during my tenure. So me going there, with other co-accused going there, the NIA, they said that they sought for the information, the foreign other agencies were being used. And the pathetic investigation is that there's no reply.
Very well.
Now, my lord will kindly, yes, as I was referring on the last occasion, that there was a disclosure statement of Arsindo Warisa on 13/7/2009. My lord, kindly come to exhibit volume 3. Exhibit 117, volume 3.
Who has proved that statement?
What a minute.
Who is the IO who has proved that statement?
Shyam Prakash Pani.
PW?
PW 146.
Volume 4?
Volume 4.
First read that statement.
My lord, my lord.
Having seen their performance, we have our own doubts whether they My lord, the disclosure was proved as required. Page number
686.
686, volume 3.
Volume, my lord, it is volume 3. Sorry, my lord, it's volume 3.
This 27, the IO has to come and say that the accused is reproduced in a statement, otherwise it is no information at all. 623,
686, my lord.
86, read.
Page 686, PW 146.
Yes,
PW. PW 146. Shyam Prakash Pai.
yes, yes.
In the instant case, I was assisting the CIO Sri Mukesh Singh, then superintendent of police in NIA. I was also superintendent of police during that point of time, that is 2009. This was the first case of NIA, which was registered after the creation of NIA. During the investigation, I was assigned certain tasks related to investigation. I had undergone a training on computer-related documents handling at NCRB, which cover courses of Microsoft, Windows, especially Microsoft Word, Excel, and Access. I prepared a disclosure memo pertaining to accused Arsingda Warisa related to his 4 email IDs. That is dimahasao@yahoo.com with password Tomahawk, Arsingda 2009 redditmail.com with password Rambo Staro, Dawa 2009 yahoo.com with password Asring, and Robert Brown gmail.com with password Ambassador AR in the presence of witnesses at SOU police station, Assam on 13/7/2009. Exhibit 117 consequently in the said disclosure memo 117/3 is my signature. All these emails were attempted to be opened on 24/8/2009 in New Delhi in presence of independent witnesses, of which only one email ID, dimahasao@yahoo.com with password Tomahawk could be opened, and 8 emails sent to NDFB 2001 yahoo.com, Harsaro Jai yahoo.com, and Arsingda 2009 redditmail.com were found. During the entire process, it was ensured that the data taken as printout from the computer was free from any virus and malware. The printouts of all these emails were taken. Because of the busy schedule of investigating as NC Hills, the undersigned was not able to carry out the recovery memo exercise, and as soon as internet access was found, the recovery memo was carried out in accordance with the provision of Section 65B Evidence Act. Albeit, no separate 65B certificate was prepared in the process. Exhibit 421 is the recovery memo, 421-1.
Where is the disclosure statement?
My lord, disclosure statement is at page.
In his statement, whether it is proved,
Pardon, my lord?
who recorded the disclosure statement?
Disclosure statement has been recorded by this gentleman.
He should state so.
No, he has not stated. He has not stated.
Then how is the disclosure statement to be read?
But that exactly the learned trial court did.
Let's see. What is the finding? Where is the hearing?
He should have said that on that particular day, that witness accused. But
Give
no,
me such statement.
Yes.
Give such disclosure,
my lord.
which I recorded in such memo.
Yes,
Yes.
my lord, that aspect your lordship will kindly see at page 204, 2004,
Para.
189. Emails sent by him to NDFB organization were recovered from the one email ID dimahasao@yahoo.com with password Tomahawk belonging to accused Arsingda Warisa on the disclosure made by accused Arsingda Warisa. My lord is there. And kindly come to para 189.
Yes.
That is page 2003. PW 146 also testified that all this mobile phone analysis led to have evidence interlinking accused persons in pursuance of the criminal conspiracy. The detailed analysis of CDRs has stated how during the seizure of the money, accused persons were in touch. It also revealed international calls made to other accused based outside the country. It is to be mentioned that the CDR analysis could not be taken into account as because no certificate under 65B Evidence Act is appended with CDRs while furnishing such copy of this service providers. Now, my lord, the learned trial court does not bring on the record of disclosure, but comes to the attribute role attributed is serial number 12, that disclosure statement has been made and I mail it. And as far as my lord, if we pause here for a moment, and because this PW 146 has given statement of other facts also, my lord, I'm just restricted here only at this point. And if we come to the cross-examination, my lord, page 689.
Of what?
The cross-exam, volume
Yes.
3,
Yes.
Shyam Prakash Pani, my lord.
Yes.
My lord, 689, fourth line.
Hmm.
Fourth line from the bottom.
Hmm.
It is not a fact that accused Arsinda Warisa was not in police custody on 13 July 2009.
Hmm.
And neither he was present in the SOU police station, Assam, while drawing the disclosure memo, because as per the court's record dated 19/6/2009 and 13/7/2009, the accused was in judicial custody lost in Central Jail. I deny the suggestion that the disclosure memo, Exhibit 117, and the subsequent action thereafter were all manufactured.
Hmm.
Your Lordship, that's why yesterday I was trying to refer to those two courts' order.
Hmm.
And if your Lordship may kindly permit me, then I will read those two orders.
Yes, yes.
19/6 order.
Hmm.
19/6 order. Since I was taken for, we were taken for interrogation on our very first arrest.
Hmm.
On 19/6/2019, on completion of police custody, Mihir Burman, Jewel Girl, and Arsinda Warisa produced before the court. The accused be remanded to jail hazard. 19/6/2009. And coming to 13/7/2009,
Hmm.
accused Mohit Huja and Samir Ahmed are produced before the court from jail hazard. Accused RS Khan and Arsinda Warisa alias Partho Warisa are not produced before the court on account of their illness. They shall be produced before the court on 27/7/2009.
They were in jail.
We were in jail.
Hmm.
Now, my lord, this aspect, the prosecution did not clarify. We did it from the IO, Chief Investigating Officer, IO, that is Shyam Prakash Pani, PW 150, my lord.
Not Shyam Prakash, Mukesh.
Mukesh. My lord, kindly come to page, the lordship has that evidence of Mukesh Singh?
Hmm.
Volume 4, page 784.
Yes.
Page 784, third para, fourth para from the bottom, my lord.
Hmm.
As per the order dated 13/7,
Yes.
13/7/2009 by the CJM Kamrup, that the accused A Warisa alias Partho Warisa was in judicial custody.
Hmm.
It is a fact that I have not recorded any disclosure statement of A Warisa. So, my lord, the CIO, the Chief Investigating Officer, admits the fact that my co-accused was in judicial custody.
Hmm.
Now, kindly come to page 785.
Hmm.
Second paragraph, my lord. I did not find any petition for taking accused A Warisa from judicial custody to police custody. I also cannot say whether any of
Mr. Burgoyne,
Hello.
if at all there was a disclosure statement and it is not exhibited, we can presume it was not put to the accused in 313. Otherwise also it can't be read.
though it was put to me,
It was put.
though it was put to me in 313,
Without being exhibited. You exhibited it actually. You exhibited it in cross-examination, 117.
my lord. And when the pointed query was put to me in question in 313, my lord, I will take your lordship to those 313 also. We have categorically stated that this particular statement cannot be is a fabricated document because my court
Otherwise,
is,
also the, Mr. Prosecutor.
Sir.
Mr. Prosecutor, how do you prove a disclosure statement without exhibiting it? And without proving that the signature of the accused is here? Huh? What kind of trial were you conducting? How do you prove on the 27th statement without proving the statement of the signature of the accused? Can you do it? The question now, a theoretical question, academic question. Can a section 27 disclosure be proved without exhibiting the signature of the accused? To that extent, the fact discovered is to be read against him. And he says that, no, I did not give such a statement. So how you will seek the proof thereof unless you prove that he has signed the document?
There is on 13.7, actually it should have been on 13.6.
Forget about it. You did not prove the disclosure statement in the statement of the IO. IO doesn't say that this is the disclosure statement I recorded on the voluntary information provided by the accused. This is the statement of the accused. This is my statement. And these were the contents which led to the discovery of certain fact. Zero. We have read the statement of 146 just now. What is to be checked? All right, carry on. Yes, carry on.
my lord,
We're going.
my lord. Your lordship, why I am just taking this issue, what my learned colleague, senior colleague has said, that there was a writing mistake or date. This is what exactly the learned trial court did. What they did when we raised this issue, it's a coincidence, I will say, but nothing. The person who passed the remand order at that point of time, we were, and the person who convicted me, coincidentally,
Were the same.
same judge. So when I raised this issue,
Hmm.
the prosecution relied upon the case diary. So that, no, my lord, your honor, it is a wrong date. I don't know, it was not put before us. And the learned trial court recorded it, overruled my argument on this aspect. That no, it can be because CD is there. And which is totally a different point of view, my lord, as far as Ankush's judgment is concerned, Supreme Court. Because if in cross-examination, if defense succeed to bring a particular point in his favor,
You can't subterfuge that through the case diary.
through case diary,
Yes,
and it is hit by 172, my lord.
yes, that's right. Okay.
That exactly that learned trial court did.
Okay, so you will be concluding in May or not?
My lord, I will be concluding. One day, my lord, tomorrow, because my other accused is there, or otherwise, my lord, if I conclude it, try to conclude it by today, because I have got some authorities.
Finish, start. Speed up your process.
My lord.
Yes.
So, my lord, if a lordship is, as far as the disclosure part is, the lordship is satisfied, then I can move to the. I will show
There is
the.
nothing like a satisfaction unless it comes in the judgment. Okay.
Yes, my lord. My lord, how the learned trial court dealt in that issue, my lord.
Yes.
I will show the paper book on there.
Right now it is all talk in thin air.
Yes, of course. Seeing this earlier judgment, my lord.
That is a good response.
My lord, this,
Para.
my lord, I'll just come. My lord, sometimes the flag marks are very slippery. It goes somewhere difficult. I will come to that point, my lord. If you please bear with me on that issue. I will come back to that. My lord, now let us come to the recovery of 1 crore and the 3 letterhead pads. The lordship will see that in the impugned judgment, when it was argued, my lord, kindly come to page 1888.
Para.
1888, para 9.
Para 9.
Para 9 in the impugned judgment, my lord.
Right. Yes.
Para 9. There were sets of lawyers who argued in this issue that the one contention was there. One of the argument of the defense at that point of time was that the FIR which FIR is to be treated as the first one, whether it will be the GD entry, whether it is the basis of PS, or whether it will be the NI, my lord. Second argument was that where did exactly the recovery took place? What is the first inception of the case?
Right.
Now, your lordship, there were 2 witnesses, punch witnesses, PW 64, that is Bunu Sonar and Dipankar Deka. Now, both these 2 witnesses were they were sponsored by the prosecution investigating agency, and their statements were recorded under 164 before the magistrate. Now, what happened when they were examined in the court, my lord, kindly see page 60, PW 64.
But you were referring to para 9 and now you're.
No, my lord. I will come to that.
You read. What do you want to read?
Para 64, your lordship. PW 64. On about 11th day, we started somewhere near Barapani. We were stopped by police in the evening hours. I do not know exactly the name of the place. The vehicle along with me and Pojendra Vajay was brought to the police station. So he says, Dipankar Deka and this Bunu Sonar, they says that incident happened as far as Bunu Sonar, Barapani. Now, PW 113. PW 113, he states in his examination in chief, before reaching Barapani, an area called Sumer, we are intercepted by police vehicle. Both the 2 witnesses are saying, my lord, it's near Barapani. One said Barapani, one is saying near Barapani, Sumer. But of course, if you take these 2 things, 14 miles where GS road that were, it is miles apart. Huge differences there. Now, how did the learned trial court appreciated this thing, your lordship?
91B.
Pardon?
Para 91B. 91A onward.
Yes, 91A. It is, your lordship, 7th line. It is further submitted that the place of occurrence falls in the state of Meghalaya, somewhere near Barapani, which is apparent from the evidence adduced by the prosecution witnesses itself. And as such, the Assam police had no jurisdiction to investigate the case. It has relied upon the evidence through prosecution witness Bunu Sonar, who stated the vehicle he was driving was intercepted near Barapani, and Dipankar Deka, who stated the evidence vehicle he was driven was intercepted Sumer near Barapani, Meghalaya. And also the evidence of CIO PW 150, who admitted the version of PW 64 and 13, PW 13. So what we did was that after these 2 witnesses said, we verified it from CIO that place of offense and the recovery effect which has been given. Do you admit what your 2 witnesses have said? He said that, yes, I admit what the version given by my prosecution, my 2 witnesses, that is Bunu Sonar. Now, what the learned trial court did, my lord, kindly come to para 91J at 1891, page number.
Yes.
It is the 4th line, 1891. It is true that according to PW 64 and PW 13, the place of interception is near Barapani at Meghalaya. The prosecution side has not declared these 2 witnesses hostile. But I have gone through the record. We find that the IO got the statement of both these 2 witnesses recorded under In a code under 164 CRPC, exhibit 263 is the statement of PW 64 and exhibit 388 is the statement of PW 13. Having gone through the same, we find that they have not deposed in the court the truth. Having taken oath to depose truthfully, they deposed in the court falsely. The reason is obvious. PW 64 was the driver of accused Pojendra Hozar and PW 13 was the driver of the vehicle, but accused Babul Kempra was traveling on the 11th date. As such, they have obliged their masters faithfully. So their evidence in respect of place of occurrence failed to inspire confidence. So my lord, can this particular evidence, if it's a normal basic principle of criminal law, that if two sets of evidence are coming, one suggesting towards the guilt and one trying to benefit the accused, of course, it should go to the other one. But here, in spite of the two prosecution witnesses who are not declared hostile, who have stated in oath that the place of offense is Barapani, verified it from the chief investigating officer, the learned trial court overlooks that fact, refers to 164 statement and draws the conclusion that they have lied. Why they have lied? Because they tried to serve their masters, that is Pojendra and Babul Kempra, because they were drivers of them. And that is why the evidence given by these police officials who seized the 1 crore and that 1 crore which could not be produced in the entire trial, their evidence is trustworthy. So they have negated the place of offense first argument of the defense, my lord. Of course, my lord, I will try to give a short synopsis of whatever I am arguing.
Yes, carry on,
My lord. My lord, PW 149.
Just hold on. That they have not even been able to prove that there was any live link between the two vehicles. But we see these two witnesses. That one who was driving the vehicle of Pojendra Hozar, he doesn't say that there was any other vehicle near. He is 66. He doesn't say that any other vehicle was near the said. It could be there that I was driving the vehicle of Pojendra. It was a report and two weapons. That's what he doesn't say that anything was the report. Prosecution does not declare him. There is nothing in the statement regarding any other vehicle being active. Same position will be like the picture. Yes. So he says, Sumit, he says, but I'm going to the vehicles, but nearby, then we have to be very specific. There is the other, the one quote. But he says that another vehicle was also intercepted, but that's all. He doesn't say that Joel Garlosa was there, this Pojendra was there, and that other prosecution doesn't even come out with that case. Yes. But then they were required. There was another case. Yes.
My lord. The three witnesses which the learned trial court relied upon.
PW 2, 10 and 26.
Yes, let us go through that PW 2, 10 and 26, madam.
Yes.
Volume 1 evidence. Page 15. I was posted at Basista PS from March 2009 as officer in charge. On 1st April 2009, I was working as officer in charge of Basista PS.
He was not there at the spot anyhow.
He was not there in the spot.
So he is no one to make a deposition regarding that. PW 10,
My lord,
that page. Maizuddin Ahmad.
Maizuddin Ahmed.
Yes.
On 1st April 2009, I was at Basista PS as a test officer. On that day, additional SP Saudagar Singh, headquarters city, and additional SP B Raskwa, along with staff, came to the police station around 6 AM. And they talked with OC Chandrakanta Boro regarding DSDJ members involved in different unlawful activities. After their discussion, the OC directed me to go with additional SP to Jorabad area for investigating regarding DSDJ extremists. During discussion, it revealed that DSDJ extremists were to move in 2 vehicles with cash and incriminating articles.
All right, what particular part you want to?
My lord,
The statement has been read earlier also.
my lord. Your lordship, what I wanted to draw upon is that from first was from PW2. PW2, your lordship, which he was being, his evidence was recorded. So in the cross examination, what I wanted to throw was that at page 20,
Yes.
that first was that on the when the examination was there, he have not seen the seized items, the PW2 in his on the day of examination, as well as the money in the court.
That the Muddamal was not brought to the court. That is what you want to say.
Muddamal, even the letterheads were also not produced,
All right.
my lord.
Okay.
Though it should have been produced because it is normally you bring the weapon or the thing because it was given a seizure effect. Now, Moizuddin Ahmed, my lord, what I was trying to refer was that he seized those, prepared that exhibit 38, if your lordship recollects, with respect to the seizure of 1 crore letterheads. Now, when our Lanad trial court relied upon the recovery, the seizure of those 3 letterheads bearing DSDJ and recovery of 1 crore as an incriminating factor against me for overall conspiracy.
Page 39.
My lord, the relevant portion is,
Yes.
my lord, relevant portion is page 38.
Yes.
Page 38, he talks about the recovery of the amount, my lord, from serial number 9. 1 red and black colored big size airbag, 10, 3 lots, bundle, 1,000, 30 lakhs, and the currency denominations, my lord. Then today I have seen exhibit 34 is a letter written to Mohit. Exhibit 35 A, B, C are the 3 blank letterhead. Material exhibit 39 is so these were the documents, my lord. These were the 2 things.
He has exhibited the documents in the court.
Yes, my lord.
Articles. Yes.
My lord. So when was cross-examined, my lord, at page 44, I do not know whether I made a statement before the IO after a discussion, OC directed me to go with additional SP to Jorabad area for investigation regarding DSDJ extremism. It is not a fact that I did not state before police that during discussion it revealed that DSD extremists were to move in 2 vehicles with cash and incriminating articles towards their direction with the purpose of purchase of arms and ammunition. It is a fact that on the place of occurrence, the BS Basista is nearer than the Subansari guest house situated at Kahalipara. In Kahalipara area, the office of the special branch of Guwahati Assam is situated. Exhibit 35 A, B, and C do not bear the signature of any office bearers in whose name the letter pads stand for. It is also a fact that anybody can make letter pads which are seized by exhibit 35 A, B, and C in DTP center. It is not a fact that Posan and Babul Kampara are from the district of NC Hills, and we have made a false theory about involvement of DSDJ in this case. It is also not a fact that I did not seize exhibit 35 A, B, and C from the accused persons, and we plan test the document to improve our case as well as to give it a large ramification. Normally, it takes 20 minutes to reach Basista PS from the place of occurrence, and in case of any traffic jam, it may take. So, my lord, what I was trying to draw from here, that he admits the fact that the seizure of letterheads, it does not make being a big crime. I can have tomorrow, someone can say like that to implicate that he has a letterhead of ISIS, so he's a member of ISIS or he's a supporter of ISIS. It can be prepared at any. Now, how do you bring it under the dragnet of 120B and bring it to 1715?
Yes.
That was a tax, honors tax of the prosecution, which they have miserably failed.
Yes.
Now, why I'm making that particular statement? Because if we see the evidence of this chief investigating officer, he, my lord, page 783, my lord. He has stated, as per the seizure list and the FIR, I endorse the fact that deposed by the Assam police official with regard to the seizure of the exhibit 35A, B, and C, and nothing new I can say to that. As per the seizure list and the FIR, the seizure dated 1/4/2009 was given at 14 Mile GS Road. I endorse the fact deposed by Bunu Sonar, PW 64, with respect to apprehending by the Assam police. So he says that as far as the Assam police version, it was in 14 Mile GS Road, the record. But he endorsed the version of Bunu Sonar.
Read that part again.
My lord, page 784.
Not that simple, because you see, place of seizure has been stated by PW 10, Moizuddin Ahmed.
Moizuddin Ahmed.
Your IO was not there, so he is no one to endorse this fact. He is no one either to endorse or contradict that fact. He is not a witness to the seizure. So how he can endorse the statement of another witness?
My lord, let us take it from one aspect.
Yes.
Who recorded this? Who prompted the recording of his statement, PW 64 under 164 statement? It was his IO.
Then it is a hearsay, gentlemen.
My lord.
What he is saying is a hearsay. Plain and simple. As you are criticizing the prosecution attempt to rely on hearsay evidence, same fate with argument.
My lord.
Read what page you are reading.
My lord, 784.
Yes. I endorse the fact deposed by Bunu Sonar with respect to apprehending by Assam police. So to that extent only your suggestion is that the apprehension was done by Assam police. What is wrong in it? Who is Moizuddin? He is Assam police.
My lord, Assam police.
To that extent he admits, all right. But it doesn't say the place of occurrence also. Don't try to read in these things, gentlemen. There is no such suggestion that the version stated by Bunu regarding the place of seizure also. This is only regarding seizure by Assam police.
My lord.
We have had some experience at appreciating evidence. Don't try to take us for a ride.
No, my lord. What I was saying, what I was trying to impress upon this court was that
Yes.
PW 64, that Bunu Sonar.
You independently can say that rely upon his statement.
My
That's a different, but he cannot be endorsed by PW 150.
My lord,
And there is no such suggestion also.
it was a mistake. There was a no suggestion.
Yes.
It was a mistake. There was a no suggestion. But your lordship will appreciate this aspect. I'm putting my this argument. There are two sets of evidences. One set is saying that the recovery was done at place X.
Yes.
That is one set. And the other set of evidence is saying, no, it is done at Y. Two sets.
Now the answer is
My lord.
that the seizure list was signed by the accused,
My lord.
right?
My lord.
So why didn't they protest at that point of time? No, seizure is not made here. So why to discard the statement of the investigating officer who had no animosity against
Initially,
it?
that could have been done at the threshold, but your lordship, that was NIA. It's a big.
Oh, at that time there was no NIA.
My lord.
At that time there was no NIA in picture. Sorry. 1/4/2009 NIA was not.
STF was there.
Yes.
STF was there.
Not even STF. Simple
No, but
Moizuddin.
it was, yes, Assam police.
Yes.
Assam police.
Yes.
So, my lord, Your lordship will try to appreciate this fact. There is a lacuna in everywhere, I understand. But what I am saying is that a particular fact.
Everywhere means it attributed to defense as well as the prosecution. Yes.
My lord, what I'm saying is that this is my case is that the prosecution has brought a particular fact, and prosecution to prove a particular fact, they are relying on
At
two-
best, you can say that their punch witnesses discredit their version for the place of recovery.
Yes.
That is the only argument which
My
you
lord.
can make. Yes.
But that argument, if it's been given, when it has been placed, the learned trial court refused that argument, except,
All right. That is why you are in appeal.
my lord, that is what I'm trying to impress upon.
Uh,
Now, my lord, regarding the contents of section 15, which the terrorist acts, which they have attributed to me, that killing of the 7 Assam police,
Page 785, last
my,
5 lines,
my lord,
last 3 lines of the cross-examination, or this is examination in chief. Examination in chief.
my lord, no, my lord, your
This is
lordship,
cross-examination.
cross-examination,
785.
785,
Yes, we have marked that.
My
Mr.
lord.
Mishra pointed that out.
my lord. So he says that there is no,
I have not investigated any violent incident committed by DSDJ
yes,
in connection with this case,
my lord,
right?
right.
That's what you're
In
relying on.
NIA case 1/2009 and 2000, there is no act of killing or other terrorist activities under the meaning of section 15 of the UAP Act. It is
Where
not
are you reading?
my lord,
Where are you reading? Page,
the lordship is page 750. There are two witnesses are there. PW,
so you are referring to this Mukesh Singh.
my lord, Mukesh Singh,
Which witness you want to read first?
my lord. My lord, 785, your lordship is,
That we have noted.
my lord,
Yes.
they have not investigated any case NIA with respect to violent activities.
The other IO is PW 149.
149.
What part you want to read?
My lord, that is he admit to the fact in page 750.
Yes.
750. It is true that I have not seized any arms during the investigation of the case.
Mm.
On being shown the Gazette of India dated 29/1, DSDJ was declared an unlawful association in terms of section 4(4) of the UAPA 1967 as per the order of the competent tribunal. In NIA case 19 and 29, there was no act of killing or other terrorist activities under the meaning of section 15 of the Terrorist Act, UAP Act.
So the declaration of DSDJ was subsequent to this case.
Pardon, my lord?
Declaration of DSDJ to be an unauthorized unlawful assist is after this incident.
After this incident.
Okay. Yes.
Your lordship, in NIA case 19 and 29, there was no act of killing or other terrorist activities under the meaning of section 15 of the UAP Act.
Right.
It is not a fact that I did not find any evidence against Jewel Girl to prosecute him under the sections of law, which I mentioned in my examination in chief.
Mm.
So, my lord, if we say if you take the charge sheet, there have been 14 factors that killing of X, Y, Z and
IO
all.
says no investigation
No
on
investigation.
these aspects.
So if there is no investigation,
Before that, the prosecution would have to examine the particular witness who makes a deposition regarding any such act.
there is no such,
So then we don't even need to see the statement of the IO.
my lord.
What is the substantive evidence to support this allegation?
There is no evidence,
So other than hearsay, news items,
my lord,
or the opinion of a particular investigating officer.
my lord.
So
No.
even if he had said I had investigated, then what? What is the hard
But there is
evidence
no
to support?
substantive evidence to support that.
What is the substantive evidence to support that?
But there is no substantive evidence.
All right. So you deal with the argument, how the trial court has dealt with this argument.
Your lordship, the trial court.
Hmm.
My lord, may kindly come to the findings of the trial court.
Paragraph.
Paragraph 423.
Mm.
It starts with 422, referring to the Sarat division's case, my lord,
Mm.
the principal. 423, and having considered all the material particulars, we find that the prosecution side has succeeded in bringing home the charge of conspiracy under section 120B against all the accused person beyond reasonable doubt.
Mm.
It is to be mentioned here that accused George Lamthang has turned approver. My lord, this part has been dealt by Mr. Sir, my lord, so I'm not repeating again, and granted pardon. And accused Samir Ahmed has pleaded guilty and convicted already. The prosecution side has been able to establish beyond all reasonable doubt that accused person, namely R.S. Khan, Karuna Saika, Jayanta Kumar Ghosh, Debashish Bhattacharya, and Sandeep Ghosh have entered into an agreement with the members of some members of DSDJ to do an illegal act, which is not illegal by illegal means, to help them in raising funds in order to commit such act, siphon of government funds for development of NC Hill district, and handed over the money to terrorist gang DSDJ through Mohit Huzai to procure arms and ammunition to assist in continuing terrorist act.
Mm.
So, your lordship, the learned trial court on the summary of the evidences
Mm.
comes to the conclusion that R.S. Khan, four accused persons, R.S. Khan, Jayanta Kumar Ghosh, Debashish Bhattacharya, and Sandeep Ghosh have entered into an agreement with the members of some members of DSDJ.
Mm.
It is not me or Niranjan or any XYZ, some members. Who are the some members? It's not been reflected. Now coming to the conclusion part of 120B,
Mm.
423(1).
Mm.
Now prosecution side has been able to prove beyond all reasonable doubt the accused Pojendra Huzai, Babul Kamprai, Mohit Huzai, Joel Garlosa, Arsinda Varisa, Valnan Chana, Malswa Kemi, Niranjan Huzai, after forming terrorist gang DSDJ in 2004, entered into an agreement with Rijaul Khan, Karuna Saika, Jayanta Kumar Ghosh, Debashish to do an illegal act to raise funds for the target terrorist gang by siphoning government funds, convert Indian currency to US dollars, to produce arms and ammunition to wage war, cause death of innocent persons, terrorize people, and extort money, disrupt works of Ghosh conversion and construction of East-West corridor. It is of concealed truth that the prosecution side has failed to establish kidnapping for ransom. My lord,
Mm.
the R.S. Khan that the charge kidnapping for ransom here in this
Okay,
case.
now when you're reading this finding, what is the basis of conspiracy between these four persons? R.H. Khan, Karuna Saikia, Jayant Ghosh, Debashish Bhattacharya,
My lord,
and Sandeep Ghosh, and these so-called factions of DSDJ.
my lord.
What is their evidence?
There's
which-
nothing on evidence, my lord.
Okay.
There is not, because your lordship will see. Your lordship will see in para 165
Hmm.
of the impugned judgment.
Yes. Yes.
Para 165.
Mm.
The first thing the learned trial court record is that, finds that the recovery of 1 crore and DSDJ 3 letterheads.
Right.
Now they come to PW 14, that is arms part in Mizoram, Vanlal Chana.
Mm.
Then Nukul Boro,
Who is Nukul Boro?
he is a driver by preparation, testing the production memo 46, where Mohit Huzai's signature was there.
Okay.
My lord. Rong Singh Lamthasa,
Mm.
that NC Hills, my lord.
Mm.
He never said that there was a conspiracy. If we see, oversee from here also.
Mm.
Kulendu Dalagafu never says of Mohit Huzai or anything.
Mm.
Amitabh Sinha,
That is hearsay purely.
purely heresy. Now, Sudhakar Singh, that talks about my arrest for my Bangalore part. I'm not denying that I
Mm.
was not in Bangalore.
Mm.
I'm not denying
Mm.
Bangalore part.
No, but what is the basis of this finding these 5 persons, R.H. Khan and Joel Garlosa and others, being in conspiracy with each other?
My lord, in that case, I'm with my folded hands. Let this answer be answered by the prosecution. I tried, I believe none of my friends can say. Let my
Because
colleagues.
that is the foundation of charge of conspiracy.
Exactly, my lord. And your lordship will kindly appreciate this fact.
Mm.
The learned trial court began the finding referring to the Panchil, the principle of Panchil of circumstantial evidence.
Mm.
And it says, the surmises that the main mantra of this circumstantial evidence is that the chain of events should be not be broken.
Yes.
If one goes, all goes. Now here the landed trial court records that yes, as far as 120B is concerned, kidnapping of RS Khan is not there. The moment it goes, the entire case falls.
Okay. Very good. Yes.
And my lord, the 423(1), the conspiracy part, I don't find any evidence or any findings. I don't find any evidence that from where the landed trial court came to the finding that Mohit Hujai, Babul Kemprai, Arsinda Warisa, Varnal Chana, Malswa Kami, we formed a terrorist gang with DSDJ, with me. For the sake, I am DSDJ. I am DSDJ. Niranjan Hujai is DSDJ because we came for a peaceful, we signed.
Right.
But so was the evidence that Mohit Hujai, he was a part of my organization. Varnal Chana was a part of my organization. Where is the evidence? I believe, and I sincerely believe, Your Lordship, it will come also. I believe their argument will be, the main point of argument of the prosecution will be, is that since DSDJ signed the peace process and you try to came in the mainstream, that means you are doing terrorist act, so you are rightly convicted. That is their argument.
Let's see. Don't prejudge.
No. My lord, that was the argument in the trial also, my lord.
No. Now we have Mr. Chaudhary here. He will improve upon things. Yes. What more?
My lord, now coming to the charge under 17 and 18 of the UAP Act, page 420, para 424. We find that above discussion and find the accused RS Khan, Korna Chaikia, Jayanta Ghosh, Debasis Bhattacharya and Sandeep Ghosh have either directly or indirectly, not certain. The finding is also not certain, whether directly or indirectly, conspired to raise fund for DSDJ, and we find from the evidence on the record that involved in raising and collecting funds for DSDJ, and they did
Why
so.
don't you reserve your arguments on these parts once the arguments are made on behalf of A4, A15, A12, and A13? There are other councils.
My lord.
Let them address, then we'll give you permission to argue on 17, 18 thereafter.
My lord.
Okay.
My lord. My lord,
So RS Gandhi kidnapping, no finding.
No finding.
Yes.
Your lordship will kindly appreciate one thing before you call it a day, my lord. Kindly come to para 450, 449.
449.
Para 449. Now, the question is whether the evidence of these 9 witnesses means, your lordship, that Anurag Thakur, Thanka, that PW24, PW26, yes, witness 9 are sufficient to establish the charge under 121, 121A of IPC against the Pojendra Hujai, Babul Kemprai, Mohit Hujai, Joel Garlusa, Arsindo Varisa, Varnal Chana, Malswa Kamik, George Lamtang, and Niranjan Hujai. The answer is got to be emphatic no. There is no doubt that the conduct of the accused, as apparent from the evidence discussed above, are subversive as well as heinous in nature. There was some killing, extraction of money, and throwing of grenade, which took place at Dimahasa. But the aforesaid five prosecution witnesses failed to give the same actual account of the incident, and also there is no documentary proof in support of the same. The document exhibited by PW24 being photostat copy cannot be taken into account, but having tested the evidence 9% on the touchstone of the parameters laid down by the Honorable Supreme Court in Navjot, it can be concluded that the evidence are quite insufficient to establish the ingredient of charge under section 121, 121A IPC against the accused persons. What I am trying to draw, your lordship, the London trial court what I'm trying to impress is that the London trial court, relying upon those 9 evident witnesses,
the trial court says that you were trying to create a separate state of the Masa, so it is not waging war against India. That is what the conclusion is.
that is what, if you take in that also.
But for doing that, you are indulging in terrorist activities.
My lord, If you're indulging in terrorist activity, there is more serious connotation is there. How? Because the section 15 says that with an intent. Now, here the landed trial court, what he has recorded, there was some killing. For example, let us presume there's some killing, extortion of money and throwing of grenade, which took place at Dima Hasar. But the aforesaid 5 witnesses failed to give the actual account of the incident. And also there's no documentary proof in support of the same. The document exhibited by P24, what was that, my lord? The case registered under Arms Act at the decassation scene, at the Haflong, recovery of huge case of arms, where I have been charge sheeted against some other person, not our name. So on the basis of that, you acquitted as of the 121, 121A. Now, on the same set of evidence, how can a conviction be recorded under section 16? Because because he himself said that there is the witnesses does not inspire us when did it happen, where it happened. There's no proof, documented proof also. So how can that set of evidence be used for convicting me under section 16?
Yes. Right.
Now, my lord, if you take some. So, coming to my conviction under section 16, my lord. The lordship will kindly come. Page, para 458. Para 456. To establish this terrorist act, the prosecution side has relied upon PW20, Ronsling Langthasa, PW23, Kolanda Dolagafu, Amitabh Sinha, PW46, Naring Dalagafu, PW26, 120 Depolal Hojai, Dilip Nunisha. We have already discussed the evidence in detail. Your lordship, all these witnesses have turned hostile. All the witnesses have turned hostile. What the IO has said, PW 150. On the basis of that, the landed
Not PW 24.
My lord.
PW 24 has not.
No, PW 24 not hostile, my lord. Sorry. PW 24, Amitabh Sinha. But that your lordship has rightly admitted, accepted this thing, my argument. Sorry. Rightly, I believe that was a hearsay. So on this basis of evidence, your lordship, how can a constitution of section 16 be made at all?
Okay, very well.
Your lordship, para 459. What we can deduce from above discussion is that DSG is a terrorist gang. And earlier, Niranjan Hojai was the commander-in-chief of DSGJ, and Joel Galusa was the chairman of DSGJ. And the activities of the organization, as discussed here in above, to our considered opinion, falls on the category of terrorist act. As is apparent from the prosecution evidence discussed above, it is true that at the time of registration of the case, DSGJ was not declared as an unlawful association. The defense side has rightly pointed this out during argument. But in view of the observation made by the Supreme Court Honorable Supreme Court in Ridal Hussain Khan, the submission of the defense side is found to be devoid of merit, and being the commander-in-chief and chairman of the organization and being member of the same, both of them are culpable for the charge. So they attributed the charge under section 16 and 20 of the UAP Act. The evidence of the record are, however, falling short to establish the charge sheet against the rest of the accused persons. Now, your lord, my lord. Just, I would like to put it in this way. If we read the charge framing, charge orders at page 4 to 6, it starts that you being a member of DSDJ, you being a member of DSDJ, extorted money, siphoned of government money, deflected government money, carried out extortion, killed people, raised money. Now, if we take it in that way, now, as far as 120B is concerned, you break everyone, we being a member of terrorist gang of DSDJ. As far as raising of money is concerned, you bring them. But to convict them under section 16 and 20, my lord, just how can be there two sets, my lord? That you say that no, the evidence is brought on this. As far as these persons are concerned, they goes away. Only Jewel and Niranjan will be 16 and 20. So means if we take in that argument, I may be wrong, subject to your lordship's thing. If we take in that way, so for a particular incident, the learned trial court considered me as a member of the terrorist gang involved in terrorist activities. But for other things, I am not. Can that interpretation be given?
Right.
My lord, from these aspects, now, as I have already pointed, when I placed before your lordship the Nalini's judgment about the interpretation of section 3, which has been perimeter with 15 of the NIA Act.
Yes.
I would just like to, if your lordship wants on section 17 on 18, after my colleagues argue.
No, you carry on, you complete your arguments.
My lord. My lord, as far as section 17 is concerned,
yes.
my lord, as far as section 20 is concerned, my lord, punishment for being a member of terrorist gang or organization. My lord, the terrorist organization has to be in the schedule.
Schedule.
2K.
So that was not there.
Yes.
Yes.
I am not in the schedule, but as far as the definition comes, that any association other than organization systematically involved in terrorist activity. Now, as your lordship has rightly said, that there is no substantive evidence from the record that a particular incident can be attributed to me or to the DSDJ. So if there is no such, then
We have not said anything.
No,
We
no,
have
no,
asked you. We have asked you whether there is any
well,
substantive.
exactly. I'm sorry for that. Is there, if there is no substantive evidence, because to constitute a terrorist act, there has to be an act in physical, provided prior to that, there has to be a mens rea. When both the two things are not there, and when the investigating officers, they accept that they have not investigated this particular terrorist activities or any violent incident. So for that, how can section 20 come into play? Any person is a member of terrorist gang or terrorism which is involved in terrorist act shall be punishable with imprisonment for a term which may extend to life and shall also be liable to fine.
Merely being a member is not sufficient. There has to be a terrorist act of the terrorist gang.
Yes,
Then only it's.
it will come into. And it cannot be given a liberal, it has to be strictly. So when there is no investigation of terrorist activities or violent incident, how can section 20 comes into play? Now, my lord, as far as section 17 is concerned, whoever in India, your lordship, if we talk about that, which my learned senior has argued, that financing of terrorist activities, my lord, 38, 39 is there with terrorist organization, my lord. Now, if we see section 17, my lord, whoever in India or in a foreign country directly or indirectly raises or collect funds or provide funds to any person or persons or attempts to provide funds to any person or persons, knowing that such funds are likely to be used by such person or persons to commit a terrorist act. Notwithstanding whether such funds were actually used or not for commission of such act, shall be punishable with imprisonment for a term which shall not be less than 5 years but which may extend to imprisonment for life and shall also be liable to fine. Now, my lord, as far as section 17 says that whatever way, if you raise up money for a terrorist gang and you're providing it, irrespective whether for a particular terrorist act happens or not, it doesn't happen. Section 17 comes into play.
This is basically terror funding.
Terror funding.
Yes.
Now, my lord, here, from the evidence which the learned trial court looked into it, to come to my to attribute those roles, 13 roles. I don't find any evidence has come on record, or it is there in record, which says that yes, Mohit Hujai has paid certain money to Pojendra Hujai, and Pojendra Hujai had paid that money to Veneta. Veneta bought those arms, and that arms, there's nothing on record. Now, for example, my lord, second is that if we take that there wasn't 1 crore rupees, there is a 1 crore rupees. Where is that 1 crore amount? From the amount where the seizure was been given, it is there, but where is the money? But it is the prosecution thing that they did not brought the seizure list, they did not brought this the receipt for depositing that money in the bank or treasury whatsoever. But it was the defense who brought it, and the amount was not 1 crore. It was 5,000 short of that amount.
Was there in the vehicle from which the seizure was made? Babul Kemprai.
Babul Kemprai.
Babul Kemprai has not been convicted for this offense.
No.
Okay. Very
Babu, only, my lord, only it is me. Joel Garza, Niranjan Hujai.
Okay.
So, my lord, before, as your lordship has already looked into the judgment of Nalini, my lord, I would like to place a judgment of from the state of Assam, Ganesh Gogoi versus state of Assam, 2009, 7 SCC 404.
What is the principle? Read.
He was been convicted under the TADA 3-1, my lord. So since TADA appeal has to go to Supreme Court, it has went. The judgment, para 19 onwards, the operating portion which I am reading, my lord. On perusal of the provisions of section 321, it is clear that section 321 has to be read with section 31. What is section 31? Punishment for terrorist act. Whoever with intent to overcome. The provision of section 31 has been construed by this court in several cases, and reference in this connection may be made to Hitendra Vishnu Thakur versus state of Maharashtra, wherein the learned judges explain the ambit of a terrorist act, which has not been defined in detail under TADA, clause H of section 21 of TADA. Define terrorist act to mean the same thing as assigned to it in subsection 1 of section 3. Section 3(1) of the said act is therefore very vital for understanding the true meaning and purport of terrorist act. It is clear from the perusal of section 3 and its interpretation in Hitendra Vishnu Thakur that the requisite intention is the sine qua non of terrorist activity. That intention is totally missing in this case. It is not there in the charge, and it has also not come in the evidence. Therefore, both the framing of charges against the appellant under section 3(5) and his conviction under section 3(2)(1) of the said act are totally bad in law. So, my lord, which I was referring at that point, when if a lordship see para 4 and pages 4 to 6 of the charge order, framing of charge, even if it is section 15, it starts with the word intent. So it is not a question of defect of charges. It is what I am to be tried for, my lord. And the Supreme Court has kind from like Katina of judgment, and this judgment which I am relying, which I place before my lord's consideration, it is very clear. It is not a question of defect. It has to be an intent, because the mens rea part has to be there. Act is just a follow-up. So here, as far as if we see, no investigation, no terrorist incident, no intention, and a conviction has been reported.
Very good.
My lord, there is other accused is there, Partha Varisha. Let my colleague for Niranjan Hooja argue. I will come back later on, my lord.
Mr. Chaudhary, tomorrow we'll hear your reply to the arguments which have been made so far. Because the other part is a different kind of allegation of defalcation and everything. So we'll hear it in parts.
Lordship, I'll start with the arguments made by Mr. Mishra first.
Yes. Tomorrow we'll hear it. Okay. Well, arguments. Hearing continues. Please further reaction about.
And, my lord,